who may be streaming the meeting either now or later on YouTube. I'd like to call this meeting to order. For the record, this meeting is being held on March 20th, 2024, at the Sparta Township Municipal Building located at 65 Main Street, Sparta, New Jersey. The time is now 7:03 p.m. The live stream for this meeting can be viewed at YouTube at www.youtube.com/& Sparta Township, which is SPARTATWP. Please note that adequate public notices of this meeting was given in accordance with the Open Public Meetings Act. I ask that everyone please join and stand on our board as we begin the meeting with a salute to our flag. I pledge allegiance to the flag of the United States of America
and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, thank you. Thank you, everybody. Dory, can we have a roll call?
Yes. Justin Canellis,
Here.
Ernie Reichstadt,
Here.
Christine Dunbar. Here. Mike Sylvester, Vice Chairman Bill Enright,
Here.
Chairman Ron Day,
Here.
Deputy Mayor Dean Blumetti,
Here.
Nicholas Pompilio,
Here.
Jeanette Burke. Here. Celeste Luciano. Here. Ryan Caruso.
Okay, thank you. Before we get into the formal part of the meeting, I just want to take a minute and I want to congratulate Nick Pompilio and Ryan Caruso, who have received their certificate for successful completion of their land use law and planning from New Jersey. So congratulations.
Thank you. And frame it.
Okay, the next item on the agenda is approval of minutes. And we have three sets of minutes that we're going to present tonight. We're going to try to approve. And I just want to take a minute and just kind of talk to the minutes for a moment, if I could. We've had a lot of discussion, a lot of debate on what should and should not be in minutes. So the group that have worked this and put a lot of effort into it, we've all come up with something that we think is good. We still have a ways to go to get into where we want, but we've got three sets of minutes for tonight. So I want to thank the people that were involved in all that. So with that, the first set of minutes is January 17th, 2024. So Tom, if I could, just so I understand, if we have comments, do we do that first, or do we make a motion and then do comments?
Unless you know exactly what you're changing right now, Ron, you would, best thing might be to get a motion, a second, and then have a discussion, and whoever wants to propose a change, propose it with detailed
Okay, I've got,
language. If you want to just postpone them, you could just postpone them.
I think, again, the people have done a lot of work here, and I'd like to try to drive these across the finish line tonight if we can, and we may be able to, we may not be able to, but I think I'd like to at least give it a try, and then we'll go from there. So I've got a few minor changes to the first one, but why don't we just start with, would anyone like to make a motion to approve the minutes of January 17th, 2024?
I'll make a motion.
Would anybody like to second?
I'll second.
Okay, so comments. I've got a few minor comments that I could go, or does anybody else have any that they'd like to go with first? Okay,
Oh, you run.
what's that?
Oh, you run.
Okay. All right, let me just start off that. Okay, so on the first page, I'm sorry, on page 11, there was a numbering sequence, and that was my fault, so I apologize to everybody for that. And so we just correct that. On the very end, we need to have a signature block. And I think that's all I had on that one. Does anybody else have any that they'd like to bring up?
Yeah, I'd like to have one addition made.
Yep.
On page 3, under the town council update that I gave, where it mentions that a new mayor was appointed, I would just like to have Neil Clark's name added to that. Neillclerk.
Okay. Does anybody else have any comments? Okay, so, do we need another motion to approve it with the changes?
The moving party needs to say they accept the changes, and the second party needs to say
Okay.
that, and then a roll call.
All right, so I'll move for those changes.
Okay.
I'll second.
Okay, great, thanks. Roll call?
Justin Canellis,
Yes.
Ernie Reichstad,
Yes.
Christine Dunbar,
Yes.
Vice Chairman Bill Enright,
Yes.
Chairman Ron Day,
Yes.
Deputy Mayor Dean Blumetti,
Yes.
Nicholas Pompilio,
Yes.
Celeste Luciano.
Yes.
Okay, fantastic. The January 17th minutes are approved. The second set of minutes is dated February 7th, 2024. Would anybody like to make a motion to approve those minutes?
I'll make a motion.
I'll second.
Okay. Okay, for comments, I've got a few here, and again, these are typos, and I will take the responsibility for these typos. I think that just to keep it clear, we need to add some page numbering. The seventh, was it, where was it? Page 4. 2, 3, 4. Oh, here's, in the middle of the page, there's a paragraph there. In the middle of that, it starts where Ernie Reichstad said. It should read in the middle, the proposed standard would not coexist well in the more commercial areas instead of a commercial area. So if I get that change. And again, I think we talked, and this needs a signature block as well. So those are my changes. Does anybody else have any changes that they'd like to see?
I have two changes.
Okay.
I'd like to propose. Both minor corrections. First one is on page 1, number 3. Line number 5, I believe it is. 6, sorry, line number 6. In the middle, it talks about, actually, I was explaining further, ... And it talks about the inclusion of other parties in the process for the open space work. And instead of Highlands Council, it actually should say Land Conservancy of New Jersey. That would be the organization that's
Okay.
running it and reaching out and having open dialogue.
Thank you. Any others?
Yep, page 2, number 6. In the copy I had, that the entire commentary under number 6, I believe actually belongs under number 4. It's about the Highlands Regional Master Plan Amendment meetings. I think that blurb
So
belongs
you
up.
just want to move that up top and combine it with 4?
Yeah, I think
So
that,
we'll have 5 items and we'll combine 4 and 6?
no, I think we still have the 6 items, but I think the commentary.
move it up?
Yeah,
Okay.
the description or the,
So 6 becomes 5 and 5 becomes 6.
no, I think the,
Here.
so just the part that starts with Chris Dunbar,
Right up here,
yeah, this whole write-up
right,
belongs under number 4.
under 4.
Yeah, 6, and I believe
So
6,
6 goes away, and so,
6 stays, but just the title stays.
oh, okay,
Yeah,
now I
yeah.
see, okay.
Yeah, there was
okay.
no, I don't
Dory,
think
do
there
you
was
do you understand what he's saying there?
Yes, I do.
Okay, great.
Okay,
Okay,
thanks.
terrific. Anything else?
Nope, that's it.
Okay,
I'll move that we go forward with those changes.
okay,
I'll second.
great. Roll call, please.
Justin Canellis,
Yes.
Ernie Reichstad,
Yes.
Christine Dunbar,
Yes.
Vice Chairman Bill Enright,
Yes.
Chairman Ron Day,
Yes.
Deputy Mayor Dean Blumetti,
Yes.
Nicholas Pompilio,
Yes.
Jeanette Burke,
Yes.
Celeste Luciano.
Yes.
Okay, great. And then the last set of minutes is from our March 6th meeting. Would anyone like to make a motion to approve these?
Make a motion.
I'll second.
Okay, comments? The only comment I had on this one, again, is I think it needs a signature block. Anybody else have any other comments? Okay, seeing none, why don't we do a roll call? Or do we, I guess we need to,
Yeah, but
Motion
Ernie
to-
and Jeanette, or whoever moved it and seconded should confirm that they
Yep.
accept those that change.
yep,
I'll move we accept those changes.
A second.
okay. Roll call, please.
Justin Canellis,
Yes.
Ernie Reichstad,
Yes.
Christine Dunbar, Chairman Ron Day,
Yes.
Nicholas Pompilio,
Yes.
Jeanette Burke,
Yes.
Celeste Luciano.
Yes.
Fantastic. We have 3 sets of minutes tonight. Congratulations, everybody. Okay, moving to the next item on the agenda is our correspondence. We have one item. But before we get into that, again, I just want to talk about this section a little bit too. You know, when I look at decisions that are made on this board, I like to make sure we're all in agreement. So one of the things that we're doing a little different here is that in the past, we used to list residential type information, such as if somebody's getting a septic repaired or not. My feeling is this board doesn't deal with residential uses, and I think we're trying to streamline the meeting to get to the point that we're all getting out a decent hour. So my recommendation is that we not include those any longer going forward. If anybody have any objection to that, certainly, please speak up.
If you don't mind, if I could just clarify, that
Yep,
wasn't
please.
necessarily just for septics. It was NJDEP information that comes through.
Agreed.
So it
Right.
wasn't for a septic permit. It was for anything that had to go through NJDEP for a septic.
But related to a residential
That is
use.
correct, but related to residential.
Yeah, and this board, really, we look at more the commercial uses rather than the residential. So just one less thing that we're looking at and, need to talk about, was the thought process.
Where would that go, Dron?
Was that?
Where will that be handled?
Yeah, I mean, typically, I'm guessing that within the town, we typically don't handle it. We would just it was on our list, but if we don't approve anything like that, we don't discuss anything like that, it was just on the list. So I just figured, just to try to help streamline this meeting, it didn't make sense to me personally, so. Okay, so if no one has any objections, we'll just go forward and we will no longer include those. Okay, so that's correspondence. Okay, so moving on to the next item on the agenda.
Can I ask a question about
Yeah,
the correspondence?
Yep.
So I'm not sure if anyone has the answer to this. Perhaps our professionals might, but does anybody know what this company does and what this permit is allowing? And if we or any other party does any due diligence on
It's
this
recycling,
approval?
recycling, I think is what they do.
It looks like they were getting some type of a renewal of a permit.
Yeah.
Allows like certain types of machinery.
Of a recycling permit. And again, it's not the kind of thing that we deal with here. I would even question, do we include these kind of things? But because it was have to do with the business, I figured let's leave it on. Again, it's for informational purposes only for the public, in case anybody wants to investigate it.
But my question is there any action, if this is related to a zoning issue or if this change has any bearing on land use? Is there some action or some attention we might want to give to it at some point? And maybe it's not this exact one, but
No, there's nothing the board does on this. It's a confirmation by the applicant to the DEP of their renewal of their general approval of a recycling facility for reliable wood products. They've been there for many years, and they're continuing. It's on Houses Corner Road, I think.
yeah, yeah.
And if you drive by, you probably have seen behind, to the right of Grinnell Pavers, significant recycling facilities, something called a MRF, Municipal Use Recycling Facility. And then near, or in front of that is this reliable wood products, and they recycle, I believe, trees and tree stumps, and I don't really know, that's not our job, so.
Yeah.
It's been in existence for many years. Generally speaking, DEP preempts the field of recycling and of solid waste management.
So I guess we can safely assume that if anything changes over the years with their operations that would create a concern, the DEP, through this permitting process, should pick up on that. I'm just thinking if
Yeah,
that
I'm
is
not
right
sure
by the
I'm
aquifer.
satisfied that the township would be satisfied. I don't know.
Yeah, yeah.
But the DEP has to be satisfied, and they regulate recyclers, and they perhaps inspect them and do, there are a series of significant sets of regulations of recyclers and of solid waste management facilities. And so that's their jurisdiction, the DEP's jurisdiction.
Okay.
Any other questions?
Thanks.
Actually, I have a quick question. So if this wasn't directly CC'd to us and it's not something that's within our purview, so why does it generally get shared with us?
I agree.
I mean, because to your point, obviously, if there's nothing actionable, you know, it shouldn't be shared with us. But if something is shared with us, I unfortunately think that we have to disclose it because it's been shared with us. You know what I mean? Even if it's not an action
Well,
item, it's
and-
not something we have to deal with, you know.
And the
we could
question
just
is, who's
blast
it
through
shared with?
Right, right,
This, I don't
that's-
believe, came to the planning board per se.
Oh, okay. So this wasn't something that should have directly come to us. Okay.
Anything NJDEP related comes from the township clerk's office. It comes to my attention as the department head for planning and zoning. So it's really just an FYI for informational purposes. That's all.
Okay, so at that stage, once it comes to us, do we then have a responsibility to disclose that we received it? Okay,
Not to my knowledge, correct, Tom?
just want to make sure that we're following.
There's nothing about responsibility here. I mean,
Okay.
it's really just, like Dory said, the clerk's office gets these notices. They regularly send them to the planning board secretary, so she put it on your agenda. So.
Okay. Thank you.
So let me take that a step further if I could. So, again, this whole correspondence area hasn't always been there. And my thoughts are, if it's something that the planning board is not actionable for, and I think this is where you may have been going.
Right,
Do we
that's-
even want
that's-
to include it?
Right, that was the question.
and-
If we have no responsibility to have due diligence.
Right.
Yeah, I absolutely agree.
Right. So, would anybody else disagree with that? I agree with it.
I'm not sure.
Okay.
I don't know if it necessarily needs to be a talking point on the agenda,
Mm-hmm.
but as an FYI, for us to receive it as a distribution, so we're aware of what's happening in town,
Okay.
different properties, different zones, things that might, NJDEP things are usually on the more sensitive side. I would still like to be made aware of this, whether or not we have to discuss it during the meeting. Maybe that's a different topic.
I would agree with Dean on that.
Okay. So kind of where we ended up, where we landed in the discussion we're having up to this point was, if it was residential, we weren't going to include it anymore. Anything to do with commercial, we'd keep it on there. And so why don't we continue to do that, and we can kind of talk them out one at a time, and in the future, and determine is this the kind of thing we want to continue doing? Or do we just make notification outside of this meeting, just, email copies to everybody on the board? So, okay?
And Ron means single-family residential, Dory,
Thank you.
not multifamily or
Correct.
similar.
Okay, thank you.
Okay? Okay, great. Thank you, everybody. So let's move into the public hearing portion of the agenda. So tonight, we've got Planning Board Application 708, Plus Holdings LLC, 53A Sparta Avenue, Block 5019, Lot 23, Site Plan. This is being carried from the February 21st agenda. So gentlemen, welcome back, and please come forward.
Thank you. Mr. Chairman, members of the board, for the record, Brian Kukowski, Cody Alfieri Jacobs on behalf of the applicant.
Sir, can you use the microphone, please?
Plus Holdings. Sure it's on? Okay. Let me tell you where we were before and what we've done since then. We were last before the board on January 17th. You heard testimony by Robert McNerney and Callisto Burton, our civil engineer. At that meeting, various questions were raised, and we submitted additional documentation to the board as follows. We have a revised site plan dated February 8th, 2024, which it was to be responsive to the comments that we received, the technical comments and those from the board. We also submitted correspondence from Mr. Burton, which is dated February 7th, 2024, which outlines what revisions were in fact made. We also provided a traffic impact study, which was updated again from Burton Engineering, which was dated February 13th, 2024. And we have provided an updated rendering for the facade of the building, Legerio Architecture, which is dated March 4th, 2024. Legerio worked with Al Detoli on that. So tonight, to testify, we have Mr. McNerney, Mr. Burton, and Mr. Detoli, if necessary. In addition, there were a couple questions that were asked, and I figured I would hit them head on. One was about the school bus stop. We made inquiry to the Board of Ed. Mr. McNerney did that directly, and we were advised that there is currently a bus stop that goes into the shopping center at 55 Sparta, and we can make arrangements that any school children would easily be able to walk there. Typically, what was observed was that the bus parks in that parking lot and parents would drive children over to the bus. The other issue that came up, we received certain reports from borough professionals, which I'll identify in a moment, but one was from the police traffic department about the driveway configuration. Mr. McNerney will testify that this site was not a pristine site and the uses that existed for a long time. The driveway configuration in terms of the Burger King and the adjoining shopping center exist through legal instruments, the easement rights that they have, which cannot be altered. And that configuration has existed since the property was previously used as a hotel. So what we received from the borough was a memo from the Division of Health, that was February 9, 2 Traffic Bureau letters, February 2nd, February 9, an updated memo from Mr. Simmons, February 16th, a memo from the Fire Prevention Bureau, February 14th, the Department of Utilities dated February 15th, and a supplemental review from Harbor Consultants also dated February 15th. So I think to bring the board back to where we were, I was going to request that I recall Mr. McNerney first, unless there are any questions of me. So Bob?
Okay.
McNerney, you understand that you are still under oath.
I do. I'll give you the mic and I'll try to speak loud.
Excuse me, I'm sorry. I defer to Mr. Collins. I have a question that goes to the jurisdiction of the board and the adequacy of the notice. I'm happy to let the applicant proceed and reserve my comments on jurisdiction to the public comment period, or I'm happy to make my jurisdictional objection now at the board's pleasure.
You should make it now. You're objecting to the notice, so you should make it now.
Okay, and the applicant will have an opportunity to respond. My name is Anand Dash. I'm an attorney licensed in the state of New Jersey. I reside in Sparta. As the board's attorney and the applicant's attorney well know, pursuant to the municipal land use law, section 11 and 12, that the notice requirement under the statute is jurisdictional in nature. If the notice is defective, it affects the jurisdiction of the board, and any action taken by the board in such case is a nullity. That's the Northgate Condo versus the Planning Board, New Jersey Supreme Court, 2013. The requirement of the notice under the statute, under the cases, is to provide and inform the public of the nature of the application in such a common sense manner such that the ordinary layperson could intelligently determine whether or not to object or to seek further clarification. Now, it is not essential that an applicant notice each and every variance, and the custom and practice has been to have a catch-all notice provision that indicates that if any other variances are required, the applicant will duly make that application to the board. In this case, the notice does provide such a catch-all provision. However, what the notice does not provide, in my opinion, and for the board's consideration respectfully, is a appreciable and noticeable variance, in my opinion, which goes to the impervious coverage. So if you look at the notice that was provided and is on record with the planning board, it makes no reference to any variances other than the catch-all provision. However, when we review this application in connection with Sparta's Township's ordinances and focusing strictly on the impervious coverage, which is a significant aspect of any land use matter and which is a matter of concern to the public, if there is such a variance should be explicitly stated in the notice. I think we can agree that there's not. And I submit respectfully that there's going to be disagreement as to whether or not such a variance is required. My position is that under the Township Ordinance, Section 18-8.5 L1B2, subset 2. We are in the TCC zone. The TCC zone permits impervious coverage of a maximum of 40%. The applicant is presenting a development that has approximately 60 or slightly over 60% impervious coverage. However, if we read the language of the ordinance, okay, it provides, and I quote, maximum impervious coverage for 4-story buildings shall be 80% with the condition that 15% of the total units in any 4-story building shall be for sale units that are voluntarily offered as part of the application to a land use board. So I'm starting with the premise that the ordinance TCC zone permits 40% impervious coverage. The applicant has proposed 60%. In order for an applicant in the TCC zone who is taking advantage, who is availing themselves of the incentives, the applicant must provide 4 for-sale units. The legal notice that's been provided indicates a total of 6 rental units and no for-sale units. So either the applicant requires an impervious coverage variance for which it has not noticed, or it requires to give notice that 4 of its units, or 15% of 40, are for sale units. Point number 1. Point number 2, the application notice, the legal notice, also makes reference to a resolution, okay, dated December 16th, 2020, in which the applicant indicates that that there was a, quote, 70-unit apartment multi-building previously approved by the planning board at the property. My objection with respect to that aspect of this notice, the legal notice, is that it is misleading insofar as that resolution was approved without the knowledge of either, I shouldn't say without the knowledge, without the disclosure of the fact that there was a deed restriction on the property that precluded planning board's approval of this application. By operation of a deed restriction on record with the county clerk, the approval could not proceed by operation of law and by operation of the deed restriction, which restricted the application to a motel use only. So to disclose in this legal notice that there was a prior approval for 70 units suggests to the public that 70 units was allowed, but 40 units should be equally allowed. Because of that deed restriction, at the time, this application, the prior application, shouldn't be referenced without a hearing, without some further deliberation and re-noticing as to the appropriateness of that prior resolution. Third point, there is a lis pendens on this property. A lis pendens puts the public and the planning board and the applicant on notice that there is litigation surrounding this property, and anybody, private citizen, should proceed at their peril with respect to an application that has a lis pendens. When I last checked the Sussex County Clerk's records, the lis pendens is still of record. And without that lis pendens being removed of record, it creates a legal issue for this board to proceed. And at a minimum, the board cannot proceed without the notice clarifying why there's the deed restriction on the property, whether or not it has been removed. I believe it has been removed of record, but not at the time that the application was approved in 2020. So those are my 3 points. I'm happy to hear the applicant's counsel's rebuttal to that, and I just would respectfully reserve the right to respond. Thank you.
So, Mr. Collins, if I could, just
Mr.
from
Mr. Chuk,
the proper way to proceed here.
the proper way is the applicant's attorney should address the objection.
Thank you. First, whatever objection was waived intentionally because Mr. Dash was here in December when we started the application. Anything that he said this evening could have been said at that December hearing. He was present for the hearing. Whether he decided to stay or not was his election, and he's raising these matters now. However, to discuss the substance of each particular objection, with regard to the jurisdictional issues, I don't believe Mr. Dash was here. In the January meeting, we discussed the necessity for a variance, and the board determined that it was not required in consultation with its professionals, the planner, and the attorney at that time. We had a discussion about that. It is the coverage. We're providing the requisite number of affordable housing, which will be rental units. So one was not dependent on the other. The deed restriction, again, irrelevant. That deed restriction has been extinguished. Whether it happened before or after the application, this board does not get into deed restrictions. This board gets into land use applications. If there was a legal impediment, then it's up to the applicant to deal with it. But we're talking about something that has been distinguished. It doesn't matter. Factually, this board did grant an approval for 70 units. There's nothing inconsistent or confusing about that. It's a fact, and that resolution is of record. The third aspect of the lis pendens, our title search did not reveal a lis pendens. We are contract purchasers. We did that title search several months ago. There is a lis pendens. It will have to be dealt with at the time that title is closed. So none of the issues that have been raised would affect the jurisdiction of this board. This board determined that it did have jurisdiction at that December hearing.
Thank you. And I omitted my final argument, and so you certainly should feel comfortable in responding to that. The ordinance also provides, with respect to the requirements of notice, that as part of this application, the developer, this is 18-8.5G, 18-8.5G states, the developers shall obtain written permission from the Township Council endorsing the developer's plan for satisfying the affordable housing obligation created by the proposed development, which shall be submitted to the Township Planning Board or Zoning Board at the time the application for development is submitted for review and approval, and shall be considered a condition for the application being determined complete. And if the applicant is seeking a waiver of that requirement, which I understand it is not because it's not in the public notice, then the applicant needs to notice for that waiver or alternatively comply with the requirement. And as I understand, my review of the record reveals that there's been no waiver for this requirement. There's been no request for a waiver for this requirement. And as such, the notice is deficient because it goes to a material aspect of this application. And to council's point, defects unnoticed are not waived. They can be raised at any time. I rest on that and defer to Mr. Collins.
Thank you, gentlemen.
Want me to address that?
Sure.
This application is based upon a zoning ordinance that was created to address affordable housing, which was implemented by the Township Council. It specifically provides for affordable housing, and it was part of, to my knowledge, the the Housing Element Fair Share Plan that was created to address affordable housing. Therefore, the Township Council has already acted on this.
I'm not, I'm sorry, could you just say that again, please? The township, you have you have satisfied 18-8.5.
The Township Council acted upon this through ordinance and endorsement of the Housing Element Fair Share Plan.
Okay, that's a question for this board's for the board's consideration respectfully as to whether or not, in addition to the first three arguments, this developer has obtained, quote, written permission from the Township Council endorsing the developer's plan, meaning this developer, satisfying the affordable housing obligation. I don't think there's a lot of room for interpretation on that. It's either they have or they have not obtained it. And if they have, I would like to see a copy of that written permission from the Township Council in hand. Thank you.
Okay, thank you, Mr. Dash.
So I'll go over the question that's been raised. The objection is to notice, and notice was made on this matter, and notice, generally speaking, is consistent with the municipal land use law. The objections that are more substantive are part of the record that has been raised by Mr. Dash, and he will be able to present testimony on these objections to the case. The case has started, and the case the applicant is not requesting a C variance for coverage. The ordinance does, though, require, and we've checked this with our professional staff, Catherine Sermad, in her report points it out, that they do have to provide 15% for sale units. That is a requirement of the ordinance, and it does kick in when you go up to 4 stories and you have coverage over 40%. Now, this is proposed coverage at 60%, and that is allowed up to even higher percent if you actually provide 4 stories and 15% for sale units. If you go to 3 stories, you can have, you don't have to do the 50% for sale units. So since they are not requesting the variance, there is no need to request the variance in the notice. We're not here to consider a grant of that variance. Actually, we expect that the ordinance will be complied with. And Mr. Dash can throughout the hearing address his objections to that if they refuse to provide the 15% for sale units. He can address that, and so can the applicant. On the substantive issue of a deed restriction, the planning board all planning boards in New Jersey and zoning boards have no jurisdiction whatsoever over real property interests or their meaning. So even if there was a deed restriction, the zoning board or planning board of a town has no ability to interpret what they mean or to determine what they mean or to change them or to override them. They are independent real estate issues, independent of zoning. But Mr. Dash may, throughout the course of the hearing on this application, address why he contends that something is not feasible or why it is not complying with some deed restriction. But the board still has to hear the case in spite of litigation or lis pendens. Apparently there was litigation, and there may have been Liz Pendants, apparently it's been withdrawn. All of those issues are irrelevant to a planning board or zoning board because the planning board and zoning board of municipalities have no authority over real property interests. But that can be something that Mr. Dash argues through in his closing arguments and in his testimony and his witnesses. The fact that they referred to a resolution of a prior resolution does not really mean anything with respect to confusion or adequacy of notice. The notice is sufficient for purposes of explaining to the public that there is an application here for 40 apartments. And that addresses the adequacy of the notice in accordance with the case law. I agree with Mr. Dash that they've not requested any waiver, and they're not seeking one. They're not even asking for a variance for impervious coverage, so that's not an issue. And so my recommendation to the board is that the
Tom,
notice.
just the last point. Did you want to address the last point about the township requirement?
Yeah, that's for when you are trying to deviate from the requirements of the ordinance for your affordable housing set aside. Fortunately, I respect that you want to argue, whatever you want to argue on that, I'm satisfied with Mr. Dash, but on the substance of it, they are not seeking to deviate from the affordable housing requirement of 15%.
Oh, I'm sorry,
affordable.
Tom. I wasn't referring to that argument. I was referring to the requirement in the ordinance that requires them to seek a written approval from the township council with respect to their plan per 18-8.5G.
That's really if you're seeking to deviate from it. And they are, as far as I'm concerned, they must comply with those set-asides, both the affordable housing at 15% of the rental and the for sale at 15% for sale, even though it's mostly apartments. And Catherine could elaborate on that. But basically, if an applicant, this applicant is not generally speaking trying to do that. If an applicant tries to deviate from the set-aside requirement or do an in lieu payment instead of units, someone into the ordinance and under similar ordinances, other municipalities can seek to provide an alternative method of compliance with the affordable housing requirement. And if that's what they are proposing, then they can seek such an agreement with the governing body. Here, they're not proposing to deviate or seek relief from the mandatory set-aside requirement for affordable housing. So that section does not kick in. But if you want to argue
No, it's okay.
on the merits of the case, when you're doing your case, if you want to argue that point, you certainly may. I recommend that we proceed, but Mr. Dash will be entitled to present, cross-examine witnesses and present a case, and so will other members of the public. So, Mr. Chairman, I would recommend that we continue proceeding, but if the two attorneys want to argue any final points, that might be acceptable.
No, I don't have anything further other than my interpretation is just based on a plain reading. And I would just respectfully ask that the board consider that language of the statute, that my reading respectfully, that it's not necessarily tied to whether or not they comply with the affordable, but my reading of that statute, the language of 18-8.5, is that it is independent of whether or not they deviate, and it states pretty clearly that they shall have obtained written permission from the township council. But I respect this. I respect a disagreement on that, but I believe strongly that this board should please just focus on that. Thank you.
Mr. Chairman, do you mind if I just give a clarification on the reading of the ordinance? Okay. The section under 18-8.5G the section is entitled Alternative Methods of Compliance. And it starts saying, except for major subdivision or site plan approvals involving 4 or more units, or 10,000 square feet of commercial space pursuant to the optional incentives authorized in section C above. So even if the reading was that for an alternative, it's except for site plan approvals involving 4 more units. So it's saying particular developments outside of the 4 more units can utilize this section. So this project would not be included under that. But as Mr. Collins was explaining, there are other ways to create affordable units that the COA regs, the Council on Affordable Housing, Round 2 regs, and Round 1 regs allow for. Some municipalities don't. They only want to create inclusionary housing units that are creditworthy. But there are options in some municipalities, and then this ordinance entertains that you can purchase an existing market rate unit and convert it to a deed restricted affordable unit off-site from the development that's being proposed. That you can purchase, you can participate in the gut rehab program through the affordable housing program. That you can pay in lieu of it, but that's why you need town council approval to do so, because the town council could potentially be in trouble with its compliance with other portions of its COA obligation through its housing element. And so I think the point of this ordinance, the purpose and intent, which is usually what you're looking for when you're reading through an ordinance, is that the council had to approve that, so the board isn't doing it without, collaboration with the council to know what the implications might be to allow that. But I think regardless, the beginning clause of this section doesn't even apply to this application, for one. And so, I disagree a little bit with Mr. Dash. I do agree with Mr. Collins that this is a specific section that isn't applicable here.
But in deference to Mr. Dash and the other applicant's attorney, although these are not defects in notice, they may be arguments in the case that Mr. Dash wants to continue to make and that the applicant needs to perhaps, or may want to address. So, but the case should continue, and we should proceed with the next witness.
Okay, so I guess we need to make a ruling here. So first of all, let me thank everybody for your perspectives. I think, we've heard the arguments. This is basically a legal question, that in my mind, in terms of what's the legal requirements to proceed and to make proper notices and those type of issues. So based on what I'm hearing, I'm going to, I suggest that we follow the advice of our board attorney, Mr. Collins, and that we continue to proceed and hear the case.
So, Mr. McNerney, you're still under oath. Do you understand that?
Yes, I do.
And please state your name and address.
Robert McNerney, McNerney.
Mr. McNerney, you testified before this board on January 17th, correct?
Yes, I did.
And you were present for the entire hearing after you finished your testimony?
That's correct.
And I think just so that the board is reoriented, you did provide a history of what existed on this property.
I did.
Okay. Could you briefly repeat what was on the property and what's being proposed?
Yes, based upon a review of municipal records, there was a hotel dating back to 1964 that was previously on this site, along with amenities, a swimming pool. From what I understand from a review of the records, that in 1987, it was converted to an assisted living facility, which subsequently had a fire and burned, and then the improvements were demoed. Currently, what exists at the property today are the footings and foundations for these structures, along with the swimming pool. The development plan is to remove all the footings and foundations in the swimming pool to clear it down to virgin soil.
All right, thank you. And also, questions came up about, school children at the facility, if that actually occurs. And you did research into where a school bus would stop to pick up those children, correct?
Yes, when we heard the concern from the board regarding this, I did reach out to the Board of Ed, who who then directed me to the school bus operator, and I met that person and asked if in the event that this project produces school-aged children, where would they catch the school bus? And in reply, through an email, they said at 55 Sparta Avenue, which is right at the end of our driveway. And in the morning, the bus pulls into the parking lot. Cars come in, kids get unloaded into the bus. So there's a designated spot already for a school bus stop.
And in addition, Mr. McNerney, you commissioned a revised rendering for the facade of the building.
Yes, in reviewing the plan, the planner's comments, number one, and going back to the architectural section of the zone, we did ride the town to see the different type of architecture and to try to place it in sync with what's been developed through the years. And I have a concept plan. I think everybody got a copy, a smaller version.
Excuse me, Mr. Chairman, Mr. Collins, this was submitted as part of the application. I don't know if you want to mark that as another exhibit.
Yeah, do we have any previously numbered?
A1 mark from,
Okay,
which was the amenity package.
So this will be A2, and a colored rendering of elevation. Let's put today's date on it, because there had been a prior one. Colored rendering of architectural elevation.
And I think you can see from what's up on the easel here that it's a drastic revision to the plan that we originally submitted. A lot of gables, peaks, windows with round tops. Sorry. We had this problem last time, too. And a railing with a,
Mr. McNerney, I know it's hard, but if you push that back a little bit and stand on the left side of it,
The other side.
you'll be blocking Catherine a little bit, but you'll be able to show the public what you're referring to by pointing. If the easel doesn't collapse. You can aim it a little bit towards the public, because we have copies. That's good.
That's better.
So, as you can see here, 4 stories in height. We've added archways over the balconies, archway over the main entrance. Created a more like Mohawk look, shall I call it. And I think this fits in better than the other plan with what was presented in the planning report.
You have Mr. DePoli, who is the project architect, work with Mr. Lucero in order to develop that design, correct?
I did.
And then Al.
Mr. Chakowski, could you speak into the microphone over there, please? Thank you.
And you had Mr. DeToli, the project architect, work with Mr. Legiro, another architect, to come up with that rendering, correct?
Yes, I did.
And Mr. DeToli can certainly testify further as to that rendering.
Yes, he can.
Okay. Mr. Chairman, I have no further questions for Mr. McNerney.
Okay, so, to the board members and the professionals, we could ask, if anyone has questions, we ask them now, or we could hear Mr. McNerney's testimony. I believe Mr. Burton would be next,
Correct.
and then ask questions of the two of them at one time. I'd recommend we do the latter, just in the interest of time tonight. Okay?
All right. Thank you, Mr. Chairman. Kalisto?
Mr. Burton, do you understand that you are still under oath?
Yes, I do.
And please state your name and address and spell your last name.
I'll spell both. It's Calisto Burton, Calisto, Burton, Bertin. My office is at 66 Glen Avenue in Glen Rock, New Jersey.
Thank you, Mr. Burton.
So, Mr. Burton, you testified before this board on January 17th, correct?
That's correct.
And after that date, you made certain revisions to your site plan?
Yes, I took notes while we discussed the application and revised the plans accordingly.
Okay. And you also submitted those revised plans and a letter describing the revisions to the board, correct?
Correct.
Why don't you tell the board what you did?
Yes. There was a question about the sequence of construction, a minor note, but we detailed that and put the staging areas. Some board members had concerns about that. That's on sheet 2.1, our demolition plan. Then it was brought to our attention that because the curb was only 4 feet off of the northeasterly property line, that we had a variance. So we shifted the entire site a foot to avoid the variance. So now we have the 5-foot buffer. I hope I got it right, but that's what we did. That would be the, I've got sheet C 2.2 unchanged, so we don't have to mark it as an exhibit. But we took the entire parking lot and slid it 1 foot closer to Sparta Avenue. There was a comment about parking or landscaping within the parking lot. What we did was we just relocated a couple of parking spaces to create landscaped islands in the parking lot. We took 2 spaces out of the middle of the property and moved them to the lower left corner when you're looking at the plan. Okay, then we went into discussion about the amenity space. And I look at this as no good deed goes unpunished. You know, our client, we had, you knew I was the engineer on the prior plan, and we developed a nice amenity space. And so our client wanted to reuse that onto this plan. And in looking at it, we put it opposite the building, on the parking lot opposite the building, so farthest away from the site. We did that for 2 reasons. One, our client didn't really want a lot of noise by the building. And 2, it fit better over there rather than trying to put it someplace else. So in discussions, we again, our clients, I guess I got to get a new battery. We did add a bench by the front door of the building, but remember, there's units on either side of the front door. It's not like we have a large lobby and amenity area down on the ground floor. And then on the lower left corner of the building, and looking at the plan, we added another sitting area for a couple of benches over there. So that's the change we made. We'll talk about the amenity space more, I'm sure, as we go through the application. We are aware that there is low pressure in the area. So on the plans, we show a holding tank. We put a 12,000-gallon underground tank. When the mechanical engineers go and actually design the mechanical system, they will develop the actual details for the pumping system. I imagine, well, and I don't know, I think it was in the Pello review letter, whether the pumps will be at the tank. They could be submersible pumps at the tank, so you don't really even see them, or they'll be in the building. It'll be some combination, and but the mechanical engineers will do that and during that stage. Now, we discussed the woods around the property, and I mentioned some of the vegetation there is very old. It may have been planted when there was a hotel there, but that was 30, 40, 50 years ago, and a lot of it is very mature. So we added landscaping on the plan to say to fit within the current wooded area, because there'll be holes there may be something that's really dead that we should take out. So we added additional landscaping to fill in the woods. And it's easier to do it in the field rather than us to do it on a plan now. Okay. There were no lights on the building. And there was a discussion about whether there'd be any up lights, and I said, no, the only lights will be down lights. So now our plan does depict lights that shine down, and they're really at the doors of the building, and they illuminate the sidewalk. So they really don't add any appreciable lighting to the site, but they provide safety lighting where required. Then, again, in this discussion about school children and how do we get down to the street and where do they get picked up, I elected to send our surveyors back out to the property and do a better survey of the driveway where it comes to Sparta Avenue. And that's a new drawing 2.8.
Now, Tom, that was part of the submission. Did you want to mark that or?
Not unless you've got a colored rendering or something, or are you going to mark it? So yes.
I am going to mark it because we cleaned it up a little bit. We took the topography off.
So that'll be A3. And just to identify what it is in its title block or
I
something.
called it Exhibit 1, Detailed Driveway Plan Exhibit.
Thank you.
All right. Although we now know that there is a bus stop on the adjoining property, but first let me explain. So Exhibit A3, our driveway comes down the center of the plan. And that's the driveway that enters the site. The Burger King is to the left, and the small retail building I'm sorry, the Burger King is to the right. It's 2 retail buildings are to the left. This also shows the driveways. There's 2 two-way driveways going to the north behind the retail buildings, and that driveway connects both the adjoining retail buildings. And there's also a driveway, an exit driveway from the Burger King. That's towards the rear. And towards the front, there's the exit driveway from the Burger King drive-through that comes out onto our driveway. So I also wanted to do a survey because the survey we were working from wasn't done by our office and really didn't detail along the side of that retail building because we wanted to fit a sidewalk in. So we had to make some adjustments and make sure we could fit a sidewalk in. So we show a 4-foot sidewalk coming down the entire driveway from the top of the hill, and we bring it right to Sparta Avenue. Now, the driveways in this section of Sparta Avenue are very close. If you were to get a new DOT permit, they wouldn't be this close, but that's the way they are. They've been here for a very long time. So the curb between our driveway and, when I say our driveway, the subject driveway and the retail building on the north side of the driveway doesn't go all the way out to the street curb. It's cut back because there's no room to go all the way out for adequate passage in and out of the 2 driveways. So what happens is when you get to the end of it, there's a crosswalk. Now, at one point, the crosswalk was painted, I'm sorry. It has since worn off. So we have 2 driveways right next to each other and sidewalks on either side of those 2 driveways and a crosswalk that goes through. So it's our intention to we're going to repave the driveway and out to Sparta Avenue, clean up the crosswalk, paint in a new crosswalk, put in a stop bar, put in a stop sign, so that that intersection is a little bit more conforming. Now, then we get into the discussion of the children. So what we've observed, because we did do a subsequent traffic study, after Mr. McNerney did his research, that the bus actually does pull in to the shopping center right next door to us and park between the 2 driveways. And we found that at the time the morning we did the study, there were 5 cars there with children. And the kids got out of the car, into the bus left, the cars left. So I imagine that if we have school-age children, and the statistics say we will, that the same situation would happen here. The one thing, though, because we have these driveways in the back, is that someone from the residential building on top of the hill could come in, drive behind the retail buildings, park, and I know there was a question about speed. You can't drive fast back there. The driveway is maybe 12 feet wide, very sharp. This is, it's traffic calming built into the design of the site. So they would come in, park in the parking lot, wait for the bus, or the bus is there already. It seems like this might be the first stop. And then the kids could leave, and then our residents would be able to go back through between the buildings and back up the driveway without ever entering Sparta Avenue. So that actually turns out to be a good thing. So they don't have to go on and off Sparta Avenue.
In addition, I believe we heard some comments from some of the board members, in particular Ms. Dunbar, regarding the EIS report. Did you do any further research in?
Excuse me, thank you.
Did you do any further research? No, I'll hand this to you. Did you do any further research regarding the environmental impact statement based upon comments that were made at the last meeting?
Yes, I did not amend the report, and probably I should have, but I was asked to look at the Conservation Blue Book, the Conservation Blueprint and the Highlands Council maps. The Highlands Council maps didn't really provide a lot, but the Conservation Blueprint was useful, and I've used it since, so thank you for the reference. We already know that the site's not in the Highlands Preservation Area, but the Highlands Planning Area. And I did not notice find through that research that there are any restrictions on the site. One thing the site did mention is that the on-site wooded area provided a medium-high water quality area for aquifer recharge. And that's good because as one of our goals was not to increase the impervious and intrude into those woods. And it's sandy soil, so it makes sense that that would be a recharge area. So we did find that area. And maybe I should have updated the EIS, but that's the extent of what I found.
So just so I'm clear, Mr. Burton, by maintaining the impervious coverage, from what you found reviewing these sites, that it won't have an effect on that water quality area. Am I correct?
That's correct. In addition, part of our drainage design is to provide recharge after our stormwater goes through a water treatment unit. We will be recharging. So actually, we will be improving the recharge for the area, for this property by, again, recharging the building roof and the parking lot.
And also, Mr. Burton, you provided an updated traffic impact study for this project?
Yes.
All right. Could you briefly go over that study with the board, what your findings and conclusions were, but also advise what you actually did to complete this study?
Yes, our office performed traffic counts, manual counts out there on Wednesday, February 7th, and Thursday, February 8th. The first count was done in the evening during the peak hour, so between 4 and 6. The second one was done in the morning between 7 a.m. and 9 a.m. The morning peak hour was found to be between 8 and 9. And at that time, the traffic on Sparta Avenue was about the same in both directions, about 470, 480 cars each way. In traffic studies, and I'm sure you've heard this, but usually you look for a peak hour. Rather than doing a 4-hour period, they came up with an hour period. So that's the traffic that was moving up and down the highway. In the evening, the southbound direction was heavier than the northbound by over 130 cars. So we had, and I'm rounding off the numbers, 550 heading north, and 680 vehicles heading south. That peak hour occurred between 4:45 and 5:45 p.m. Now, during our counts, no traffic entered the site driveway. But traffic did exit the site driveway. So we had 7 cars exiting in the morning and 33 exiting in the evening. That's again during that peak hour. And most of those 33 cars were from the Burger King drive-through. And as the cars from the Burger King exited the site, it was an even split between cars turning right and cars turning left. That's important because when we do our trip generation and distribution. The next was to use the Institute of Transport Engineers trip generation manual to determine the traffic generated by this 40-unit development. And for the peak hour traffic, it's 14 trips in the morning hour. That's, a trip is in and out, so it's mostly out, so 11 out, 3 in. And in the PM, most people are returning, so we have 10 in and 6 out, or 16 trips. Now, that's common for residential because we're saying a peak hour, people leaving between 8 and 9. Some people leave at 7:30, some people leave at 6:30, some people leave at 9:15, some people don't leave to go to work. So anyway, so that's how we came up with the peak. When we add, then what we've done is we've added that traffic to the existing traffic on the street, and I'll just, in the driveway. So again, there's no traffic entering the driveway now, so the traffic generated by this building will be the traffic that enters. So we're having 3 in the morning and 10 in the evening. Right? So that's new turns on the road coming in. And if we have 10 vehicles coming in an hour, that's 1 every 6 minutes. And half of them are coming from the south and half of them are coming from the north. So that's 1 every 12 minutes. So when you ask me the question, what's the queue on Sparta Avenue because of cars turning in, it's not really much of a queue because there's less traffic turning into here than turning into the Burger King or some of the other retail places. And when we do our actual the programs we use to do the traffic analysis actually show no queue. But obviously, there's going to be a queue. It's going to be there. It depends on the traffic lights because we have a traffic light on Main and a traffic light further north, just a couple hundred yards away, that will meter the flow of traffic across the site. As a matter of fact, we found that cars exiting from the Burger King, they may get to the stop at the curb, look both ways and go, which happens a lot, or sometimes they'll have to wait as much as 30 seconds, again, depending on the traffic flow. And that's the condition there. We anticipate future development, so what we do is we come up with a build year a couple of years from now and increase traffic because there's generally increase in traffic each year, except for when we have a pandemic or a major financial recession. Anyway, so we've added that traffic together. So the combined traffic leaving the driveway would be 18 in the morning and 39 vehicles in the evening peak hour. And as I mentioned, 3 coming in the morning and 10 coming in the evening. Then what we do is a level of service analysis. And because there's so few vehicles really coming in, there's no change in the level of service on Sparta Avenue. It's negligible, the change.
Just a couple follow-up questions is that basically what you found in your trip generation would be considered minor using NJDOT standards, correct?
Yes, we will have to go to the NJDOT for the changes we're doing in the driveway. It's occupancy permit, and normally we would get If we weren't doing that or tying our drainage into it, we would get a waiver. The increase in traffic on the driveway is less than 100 trips. That's the DOT threshold to be whether or not a permit is needed. We're going to go for a permit because we're going to be making some physical improvements and connecting the drainage to the site.
And based upon what you found at the site, would there be sufficient warrants that would merit a traffic light?
No, there would not. Because the state, not only the state, nationwide, they don't want to put in traffic lights where traffic lights aren't, they use the word warranted. So there's a list of warrants that determine whether a traffic light is justified at a site. And we're far from that. I mean, we need several hundred cars each way on the main road, and then for several hours, over 100 cars coming out of our driveway, and we don't have that. So we would not warrant a traffic light.
Did you also look at the existing sidewalks and existing pedestrian crossings on Sparta Avenue located close to this site?
Yes, we did. As I mentioned, that's why we prepared the plan. There are crosswalks and handicap ramps on either side of the driveway, so that's in good condition. We didn't think we needed to continue off-site to make improvements, but we did feel that we needed to do the crosswalk. And we striped the crosswalk this way. There's several ways of doing crosswalks because that's how we found it striped elsewhere. But if your engineer wants to have a different, there's different designs for crosswalks, but we matched what was in the area.
So what you're talking about now, though, is just the proposed restriping of the crosswalk of your driveway, right?
Correct. It crosses our driveway and it goes onto the property just north of us.
Right.
But it's in the right of way.
Okay, it's in the right of way because the sidewalk's in the right of way.
Correct.
Right. Now, is there, maybe you're going to go to the one.
I was going to say,
okay.
what about any of the crosswalks on Sparta Avenue?
Crossing Sparta Avenue? Correct. Oh, no,
Lewis Lane, there, did you see the one at Lewis Lane? It's fading, but there is one, and I wondered, do you think, it doesn't have any kind of pedestrian light? Would warrants exist for, it's a mid-block crossing, pedestrian crossing, which is fairly unusual, but it's existed for years. Are there sufficient warrants for that to obtain a pedestrian light or some sort of a warning system?
what has been done are lights, the crosswalk sign that would flash. So when someone wants to cross the street, they could push the button. Again, it's just a crosswalk. It's not a traffic light, because another consideration for traffic lights is the proximity to other traffic lights. And I think we're as close as you can get with traffic lights. That might be something that could be installed there. It would need DOT approval because it is in the DOT right away.
The type that warns of a crosswalk and blinks if a person pushes a button and would like to cross.
Yes, we do that in places like Jersey City all the time.
And you think maybe the warrants would exist for that because of its location, or what do you?
I don't know if there's a warrant for that, but if the mid-block crossing is permitted, then
I think it must be, because I'm thinking it's a state highway, and I don't think we painted it, but I don't know.
I just worked on, well, anyway, on the county road where there was a mid-block crossing, and the county says, "What's that doing here?" I says, "No, it's been there for 20 years." So they made us take it out. Anyway, if the crossing is and it's got to be legit because it's there and it has been painted, then I don't see a problem in having the crosswalk sign put in.
Based upon that, Callisto, would the type of sign differ depending on what DOT would permit? Would it just be a sign, or could this be a flashing sign, or does that need any specific permission?
Any sign needs permission. And I have not done this on a DOT road, so I don't know, but I don't see why it wouldn't be. It's again, the standard crosswalk sign where you see two stick figures crossing a crosswalk. And then it's just a matter of the pedestrian can hit the button and alerts people that people are crossing. Now, the rules are on county and town roads that when someone, the pedestrians have the right of way. I don't know if that's the case on a state road, but this is not a limited access highway, it's a local street, so that would be something we could pursue with the DOT.
Now, in addition, Mr. Burton, there was a revised report received from Mr. Simmons. I believe that was, turn the page, maybe I could find it. February 16th. Did you have an opportunity to review that report?
Yes, I did.
Do you have any comments on that report?
No, I don't think so. I could just hit a couple of highlights. I'm going to page 2 under section 3A. I asked about the maintenance responsibility for the drive. I testified last time that the applicant will be responsible for that driveway. It's part of the project now to repave it. On B, we talked about the rights to the adjoining property owners for access to the driveway. I guess Lot 2 is where the proposed Wawa is. I think I'm on D of page 3. And we're aware of it, but we were unable to find out any information. Item F, the chain link fence, my understanding belongs to the cemetery. Because it's the same fence that wraps around the cemetery property, so I would assume it's their fence. And it's in pretty good shape. When we get to item 4, A and B are just notes of what's on the plan. C says there is no room for vehicles to park on our driveway. Again, this is about school-aged children. I don't know that I put on the plan, but there is no parking and there should be no parking. So if we want, we can add no parking signs along that driveway. But I think we've addressed how school children will be dealt with. Or accommodated, not dealt with, accommodated. All right. The rest is about the traffic study, parking spaces. Okay, so number 5. A is a comment. B is the waiver. We talked about this. 4 loading spaces are required, 1 space is provided, and I mentioned that, once the apartment building is full, turnovers every couple of years, and it would be a waste of asphalt to have more than 1 loading space. Now, C requires a 4, okay, that's right. A 4-foot setback for the parking to the sidewalks. And I mentioned last time that when the cars are parking up against the sidewalk, we'd rather they don't walk through the grass to get to the sidewalk, and we brought the sidewalk right to the parking spaces. That's the sidewalk in front of the building. 6B.
Do you make the sidewalks a little wider there? Where the car would, I guess the car is going in over the sidewalk and the curb for a couple feet or something like
Yeah,
that?
18 inches or so. But the residential site improvement standards specify a 6-foot sidewalk.
Oh.
We show a 6-foot sidewalk. If you'd like us to make it a little bit bigger.
No,
we
that's
could.
fine. That's
Okay.
what I wondered. Do you have the 6 feet, where you have car overhang, you have the 6 feet? Or where there's a potential car overhang, you have the 6 feet?
Yes.
Okay.
Whenever the parking is perpendicular to the curb, or right, and we would have a 6-foot sidewalk.
While we're on sidewalks, could you just describe could a person walk from Sparta Avenue all the way up to the parking lot and then to the building somehow?
Yes.
On a sidewalk? And could you
Yes.
just show how that occurs?
Drawing.
It's one of the ordinance requirements, but take us from Sparta Avenue up.
Sure. So we have the new crosswalk on Sparta Avenue. The sidewalk is on the north side of the driveway, or as you're walking in the driveway, it's on the left side. It follows the driveway all the way up to the end where we get to the parking lot. Here, what we've done is we've crossed the driveway
With a crosswalk?
with a crosswalk.
Okay, and a stop sign too? Like,
Well, we
how does
have,
a person-
we have pedestrian crossing signs on either side.
Okay, and then you go on a crosswalk.
And then on the other side, this would be on the northeasterly side. I guess if north is up, it's on the easterly side of that parking lot. The sidewalk goes all the way up to the building and then across the front of the building.
Okay, thanks.
And then there's a sidewalk to the front door and one to each side door. In 6B, it says a buffer has not been provided. It's a buffer of at least 5 feet in width is required. That's, that's one I thought I was trying to eliminate by creating the buffer along that.
The 5-foot buffer geometrically was provided, but what this refers to in that buffer area is some landscaping in that area.
Yes, I see we have lawn there. We could actually add some shrubs through there. We'll add shrubs. Okay. I don't think there's anything else I need to comment on unless Mr. Simmons thinks so.
The only item I'd like you to elaborate on a little bit further, if you could, just going back to the shopping center to the north side where the school bus pulls in. Question for you, is there a written agreement with the owner of the shopping center that allows that? And as far as the parents driving the children down and going counterclockwise around the back of the building, is there an agreement that allows that, or it's just a gentleman's agreement, or how does that work?
I don't believe Mr. Burton can answer that. I have the email records and the photographs from the school district indicating that that's where the school bus stops, and that was from the transportation supervisor, June Macco, of the Board of Ed. She did not indicate whether there was any agreement in place or not, just identified that's where the school bus stop is.
All right, she didn't necessarily, I'm playing devil's advocate just a minute. She didn't necessarily say that the parents coming down from the apartment complex have the right to go behind the building, though, did she?
She didn't get into that detail. She
Okay.
only identified where the crosswalk, not the crosswalk, where the school bus stops.
Understood.
We do have photographs of that, and we just wanted to confirm it. And Mr. Burton's firm did observe what occurs.
Understood.
And if for some reason our residents can't use the driveway in the back, they'll go out to Sparta Avenue, pull in. I just, one of the principles of traffic engineering is to stay on the lesser order roads, and so that's why I brought that up.
No, understood and appreciated. I guess my concern, again, just playing devil's advocate, if the ownership of the shopping center should change sometime in the future, and some future shopping center owner did not want to allow that, then it might change the configuration of what was described.
Can I just, and while we're on the bus stop, would you be willing to authorize the Board of Ed and the bus company or bus provider to enter upon the driveway and come up and turn around and pick up students at the front door of the building? And if you needed to authorize a Title 39 ordinance for entry and for police enforcement to,
The answer to that is yes, if the Board of Ed would want to do that. They
right, if they would
identified
let you.
that they've identified this as an appropriate location as it's utilized today.
Right. Okay. Thanks.
Okay, and then there was also a supplemental letter from Harbor Consultants. The site plan review, it asked about colorized elevations. Well, yes. Site plan issues. So there is a question about environmental view sheds, environmental and view shed standards. So we discussed this a little bit last time, and I mentioned that from Sparta Avenue looking up at this driveway, you're not going to see the site, but from farther away, say at the intersection of Sparta Avenue or Main Street, you would probably see it. And then looking in the area, I noticed the townhouses by Sparta Bowl, behind the bowling alley. There's townhouses up there. Now, in certain areas, if you're far enough away, you could see them. From this property, we look right at each other. They're at a higher elevation. But this property is probably the highest elevation along Sparta Avenue, heading south, and Main Avenue, Main Street, all the way over to Route 15. So from far away, you will see this building. And from those townhouses up behind the bowling alley, you'll see the building. You'll see each other. I would think that from the upper floors of this building, I don't know, I forgot if it's a ShopRite or Stop and Shop over by on Route 15, from the top floor, you'll see that building. But this building doesn't block anybody's views because there's no views, there's nobody to block. We're the highest piece of property in the area, and again, it's undeveloped on actually really 3 sides because part of our property is undeveloped. So I'm not sure what the goal is, but we're not blocking anybody's views. And I guess the improvement of the building will address the visual impact of the building. Am I close?
The environmental and viewshed standards were specifically included, 25, almost 30 years ago in the master plan for environmental and historic considerations. The property is topography does not hide this building. If anything, it shows it more in the area. And so I think we haven't really heard deep architectural history testimony yet about how the changes, will impact some of the comments. But I think previously, the flat roof building, the architectural treatments, the potential for building mounted or roof mounted utilities and mechanical, there was concerns as far as how does that further the master plan goals, because this site specifically is shown in the master plan as having view shed considerations. So
I did not address the rooftop units. In speaking with the architect, the heating and cooling system will be called a mini split. So there's little condensers. Some of them are small. I mean, they could be 2 feet or 3 feet high. They'll be on the roof for the unit, and there'll be a air handler system for the corridors. They're all small, low, 3 feet. Maybe the big air handler could be 4 feet high, but there's going to be a 3-foot parapet around the building. And there's no way anyone is going to see those units because they're in the middle of the building, and you've got to get up pretty high in order to see them. And again, there's nothing higher than us except for the townhouses I mentioned across the valley. And they won't see them either. So there's nothing, from any view of the building, I'm confident that all you'll see is the elevation of the building, the walls, not the mechanical equipment.
That's all I have for Mr. Burton, Mr. Chairman.
Thank you. All right, if we could, just one more time. So, Mr. Simmons, I want to see if you had your questions answered.
Yes, Mr. Chairman, based on what I asked before about the bus stop, and when Mr. Burton went through my report of February 16, 2024, he basically followed those comments and provided some additional information.
And do you have any other concerns that arise out of what you heard today?
No, the one thing he did mention was that they were doing some additional survey work down by the intersection of their access drive with Sparta Avenue. And the one thing that I noticed on the driveway plan was it's very tight down there. There's a freestanding sign called for and what have you. And when that property line is further delineated, that'll have to be looked at to make sure they can get all the appurtenances within their own property.
Right, that's why we did the survey.
Yes.
Catherine?
So I didn't necessarily raise questions in the supplemental memo. I did, bring in a lot of other information as far as the master plan and how it relates to the application that wasn't previous in my original memo from October. I still strongly believe that the amenities as offered really, they're lacking. I don't think it meets the intent and purpose of the ordinance. I had a chance to look back at the original application that was approved back in 2020, the Captiva application, and I'm glad Mr. Burton brought up the fact that I didn't even realize the amenity space is a copy of what was from that project, and the site plan is so incredibly different from that project, and the context matters, and the driveway, and the location of the parking, and the structured parking, all matter about how that outdoor amenity space functioned. And I will say that, the location was entirely different. The location was in, the northern portion of the site, right over there, and the building wrapped around, and there was another driveway entrance that came right down to the underground parking. There was it's the driveway split. And so, my concerns are still, I think, valid. I think what I shared in the memo about this site really seems to not give deference to the pedestrian. I think Mr. Burton provided also that kind of sidewalk plan, and it concerns me that it includes signs that say, watch out for pedestrians. I feel like the site can be designed better to not need signs to say there's pedestrians walking. It just doesn't seem like it's pedestrian friendly at this point. And like I said, the other plan had a lot less surface parking. A lot of the parking was tucked underground. The amenities were located on that north side of the property about it was still a crosswalk away. It was still across one of the driveways, but it was 50 feet away from one of the side entrances to the building. This is 150 feet from the building, and I just don't see it getting utilized properly. I think it's going to be a place where snow gets dumped, in a winter month, and you're never, and it's just going to kind of fall apart. So I really think that that's lacking, and I think there are other opportunities. If the applicant believes that area is somewhere that's going to be the least noisy, I think that's the least of the worries. I'm more concerned about pedestrian safety. I'm more concerned about how usable that space is and that it meets the intent and purpose of the ordinance. And there was other things about pedestrian safety that the master plan emphasized as well. So I stated those in the supplemental review as well, in addition to the amenity space, but it all, ties together. There's indoor amenity issues. I don't know if we touched upon it. I don't know if we're going to get into that with the architect necessarily, if there's anything redesigned in the interior of the building. But again, the previous project included a significant interior amenity package, even if the outdoor amenity wasn't, was the same as this, and even despite being a larger unit density, the indoor amenity package was substantial. It was a whole community space pretty much dedicated. And here, again, it feels like an afterthought. I shared, and my office shared, a few comments about how we think that it could be done a little bit differently as far as where the location of that space is, how it would actually, further some of the goals as far as noise generation and when there's congregations, how first floor units are probably going to be the most susceptible to parking lot lights, to noise at the lobby area, and so maybe moving some of those units to upper floors. So those were shared in the memo as well. the architectural design was changed, but we've yet to hear from the architect about maybe testimony related to that, because the town center master plan does have an architectural design section that talks specifically about historic character, the textures and materials. So I'd like to hear some testimony about that from the other witness. I don't necessarily think Mr. Burton's the one to do that. But yeah, I think, I still have issues with the amenity space. I still have issues with the pedestrian circulation.
If I may, just one thing on the pedestrian circulation with the other plan. The sidewalk was still on the north side of the driveway, and as you came up, it had to cross that driveway to get to the building because the building was on the south side of the driveway. So we did, if I may, the driveway came up from Sparta Avenue and continued along that northerly property line, and there was a crosswalk to get to the building. So our crosswalk is up at the top, again, because we had to, because the sidewalk is on one side and the access to the building's on the other. Anyway, so it's not much different, and I don't think there's that kind of traffic that's a problem with the sidewalk. We can talk about the amenities and the other things.
Any other concerns, Catherine?
No, that's all I have for right now. Thank
Okay,
you.
let me go to the dais of questions. Celeste, can we start with you?
Actually good for the moment.
Okay.
I'd like to revisit one thing. I'm a little confused. Originally, we had said that this would be a 40-unit rental-only building. Did we make a change and say that now there has to be a 15% for sale? Or did I misunderstand that?
Catherine pointed out to me that the 15% for sale requirement kicks in when you go to 4 stories and over the coverage of 40% in the zone. If you were 3 stories, you can go without the for sale units, but with the affordable units. But if you're at 4 stories plus the higher than 40% coverage, those 2 incentives allow you to, if you take advantage of those 2 incentives, you have to provide the 15% for sale units, and so it is required.
So it is required.
And we're informing the applicant of that too, because that's Catherine's review.
Yeah.
And my reading as well. I think it's basically just a requirement.
Okay.
You gotta do the 15% for sale in addition to the 15% affordable. The for sale do not have to be affordable.
So, and I don't know if this explains it better, but this is how I understand it, which maybe it'll help, and I hope it'll help. The code section is entitled incentive zoning. The zoning was changed to create incentives, which is different than base zoning. It's different than bulk standards. There are less requirements and more, it changes the zone based on what you do, which is what Tom just explained. So when you do, it allows for apartment and multifamily buildings in these town center zones. The incentives for lots that are greater than 2 acres in size are that if you do a 3-story building or you do a 4-story building, there's things connected to that. A few of those being that it ups the bulk standard allowance for impervious coverage. It ups, it could be written better, the ordinance standard, because it is a little confusing. It doesn't necessarily tie the building height, in my opinion, or the number of units to that, but or to the incentive, I'm sorry, but it does tie the offering of for sale units as a set aside to the incentives to allow. And so in my view, how I see an incentive rather than a bulk requirement, a deviation from that is you either provide the 15% as part of the incentive, to get the bonus part of it. If you don't offer that, then you're stuck with the original bulk standard of the zone. So if the incentive allows you to have 60% coverage or 80% coverage if you offer that 15% of a for sale affordable units, then you get that coverage. If you don't offer those for sale units, you go back down to the 40% at the zone.
Good.
And if you deviate from that, then that's a bulk variance. So I think that was probably raised, I think Mr. Dash had raised something to that extent. I know it's unclear. It's unusual. Incentive zoning is unusual. But it only kicks in, the incentives only kick in if you provide what the incentive basis is, what it's asking for. And if it's not offered, then you don't get the incentive.
Thank you.
So for clarity, if I can, just to stay on the same question, could I hear the position from Flus in terms of, do you agree that that's the requirement and that you'll meet it?
And just to confirm, those are 6 affordable units, correct? Okay, thank you.
Well, it's 6 affordable, and that's 15%
It's for
of
sale.
40.
For sale.
And it's 15% for sale, which is 6 for sale. The for sale are not the affordable,
Right.
okay? We need the affordables to be rental
Right.
because rentals provide a
Co-op.
2-unit credit. For every rental, you get 2 units, at least under the old code rules. The new statute was enacted today and has differences about credits, but we are operating under the round 3 rules for your Township of Sparta Housing and Element and Fair Share Plan, which received a judgment of compliance from the Superior Court and a settlement agreement with Fair Share Housing Center. And all of this is related to that.
Very good.
Okay.
Good. Thank you.
The one question, I think the applicant's attorney just answered it, but does the applicant agree to do the 6 for sale units as we're discussing? Yeah. Okay.
Okay.
And one other question, the amenities that you were talking about, is that in the ordinance or a specific section of an ordinance that you have handy?
You gotta give me a second. The definition for the multifamily units, and I'll pull it up if I can, includes essentially that there is shall require. So it's not written in a way. If you give me a moment, I can pull it up. Should have had it on hand, sorry.
No, that's fine. I just didn't know where to look.
It doesn't, so normally a definition may say like an apartment building is, a number of units, stacked on top of each other or next to each other that may include, amenities. In the case of the definition, I think it was probably written with purpose. It includes that it shall include indoor and outdoor amenities, and various site plan elements. So they kind of are required. Now, there's no sizing requirement. They don't need to, provide a 10% of the total lot area. They don't need to, there's nothing like that. But there is definitely, as part of the definition, requirements that are pretty specific about, those elements.
Okay,
And
thanks.
what Catherine was trying to point out in her report, which maybe the architect could take some time to think about too, and talk about, is she's suggesting that where they're on higher floors, maybe some of those amenity rooms and storage rooms and things could be on the first floor, and perhaps even, from what I heard tonight, at sections of the first floor of the building where it might be near the outdoor amenity that could be relocated, or some outdoor amenity that could be relocated. Although that might be a noisy activity, it is a apartment style activity to have things near a building. So there might be ways to combine this recommendation that Catherine has about the indoor amenities being relocated to the first floor to also coordinate with where the outdoor amenity would be. But I'll defer to Catherine about what her point was.
Yeah, it was mostly for just, and there aren't requirements related to it, but it was really to say that it's a missed opportunity if we're not looking deeply at how these spaces are going to serve. There's no purpose in providing something simply because it fulfills the requirement under the ordinance definition. These should be spaces that are well thought out, and they have impacts on the site. This is, 40 apartments, which there are going to be residents that need open space. They need amenities so that they don't have to leave the site. to go elsewhere because it will generate more traffic. And so I think keeping that in consideration, there are purposes behind the amenities rather than just, a direct requirement.
Okay, thank you. Okay.
Has a few questions. The colorized renderings of the other three sides, we'll see those later.
Those were presented at the last meeting. Those are not changing. So those, will have the same coloring as this rendering, but we did show you the four sides. We changed the facade.
So everything we see on the front here is just for the front. This won't carry over to the
That
sides?
is correct, except for the coloring.
Have you considered following this same design, at least on the side visible to Sparta Avenue?
That is a question that I will ask my client. I'm going to ask for a break when we finish
Okay.
the questions before we go to the architecture.
Okay, thank you. I know there's a question in the Catherine's report about the parking lot design guidelines being met. Can you confirm that those design guidelines have been fully met?
Yes, I'm pretty sure they have, yes.
There was one of the design guidelines listed in the master plan amendment for the town center development design guidelines requires, number 7 requires parking lot should be designed with landscape buffers, which I think Mr. Simmons brought up, the 5-foot requirement, and interdispersed landscaped island to reduce visual impact of large expanses of asphalt. So while there's not probably a specific ordinance requirement related to the use of landscape islands or at different intermittent intervals, can you just describe some of the landscape islands that are included in the plantings on them?
Yes, this is a small parking lot, and we put, as I mentioned, we moved a couple of parking spaces to put landscape islands in the center row.
Thank you.
So does that therefore meet the 30% planting requirement of the impervious surface?
Yeah, I believe so.
Okay, I know originally it hadn't. Does this bring us to at least the 30% of the plant material?
Do we have a calculation for that, or can it be provided on a future plan?
Okay, we'll do that.
Thank you.
Thank you.
Yeah, there is an item on the plan, landscape area, 30% of impervious, and we have 48%. That could be the overall site.
I also share same concerns. We could talk more about it later, about the amenity space being insufficient and pedestrian safety risk. It seems like you can't pass a day or two in the news about reading about, in New Jersey, about pedestrian injuries and deaths by vehicles. I think it's just increasing, whether it's on public roads or even on private property like this. So I'd like to talk some more about that later. The curb cuts. So I know in Mr. Simmons' report, there was a question about curb cut to lot number 2, and I know in the police traffic safety most recent report, there was a recommendation as well to remove some of the curb cuts down further on the driveway. I heard a reference to it earlier tonight, but if you can just confirm or clarify if it would be possible to remove some of those curb cuts to stop the cut-through traffic. I know we mentioned the school bus, might be easier for some parents to get through the back way, but in terms of other people circumventing coming down the Sparta Avenue all the way.
There are easements, so legally they have a right to access. And that's the driveway shown in the front, the two Burger King driveways, and then there's 2 driveways behind the retail center.
Okay, so the retail center as well, there's easements for that. Okay, thank you. I know Mr. Simmons' report has highlighted interesting fact about the amount of material and soil that would need to be removed during the process. And I believe the rough estimate was the equivalent of 655 tandem truckloads of excess material would need to be removed. Can you just walk us through a little bit? That seems to me like an enormous amount. I'm not in this business, though. Can you explain the duration, the timing, the impact on adjacent properties, just a little bit about how that would play out?
I guess the excavation would take place over the course of a month or 6 weeks, something like that. So if we had, that would be, 20 trucks a day, something like that. Out, bringing material out. And again, that depends on who's contracting it, where they need it, there's brokers who will figure that out. But yes, that'll be material coming up. Unfortunately, there's nothing we can do on site because we're, moving into the hill. There's no place for us to use it. And that's all I can answer.
Yeah. And those would be obviously during daytime hours?
Yes.
Okay. Do you foresee a major impact on the neighboring property owners and their businesses? or-
Well, no, not really, because we're going to come down. The driveway is already beat up. It's pothole city. And so,
Yeah.
the trucks will finish it and then we'll rebuild the road. So I don't see an impact on that.
Okay.
And fortunately, there's no residences, adjacent to the property.
Just an observation, Mr. Blumetti. I was there today, so hopefully they actually put material in those potholes.
Might improve it, I guess. Okay, and just to be clear, I know that there was 2 signs mentioned. I just want to confirm your understanding that we're not approving signs as part of this process, right? You're going to come back to get signs approved at a future date, right?
If that's what it is, yeah.
Yeah, because I don't think, unless I'm mistaken, we haven't seen sign designs and anything. Okay.
Provided a sign location.
Yeah,
And a size, yeah.
yeah. But in terms of the actual look, feel, fonts, all that, you'll come back for that, okay. My next question is regarding wetlands. In the past, there was references to wetlands being in the area here. In fact, it was in one of the planning board meeting minutes back from October 2013 that
I think that's
this,
zoning board, Dean.
I think it was planning.
No, I don't think so.
Okay, it was one of the two. No, it was planning board, actually.
Oh, okay.
Yeah. And it mentioned there being wetlands in this area. I can't put my finger on if it's this property exactly, but what's the process for confirming that there's no wetlands that would be affected by this?
Well,
Is it,
first, I had looked at the New Jersey GeoWeb and then at the conservation blueprint, and I didn't see any wetlands mapped. The next level would be is to have our wetlands guy go out there and walk the site to see if there's wetlands. And then the third stage would be to get an absence presence letter from the DEP.
so what would be the second step then? Would be have someone come out there and do a certified visual inspection of the
Yeah,
property?
wetlands specialist would walk the site to see
Yeah.
if he found wetlands.
Is that something that you would consider?
They'll ask our client during the break.
Okay, just to confirm. I did see the fire department had new reports. You're aware of those, of course, about a larger sized truck being able to maneuver. That will be met.
I'll let Mr. Burton answer as to the truck maneuvering. Everything that was in the fire department report was fine.
Okay.
Could address the
Yes, and
truck.
I'll check on the size, but we already show a fire truck going up and looping around the driveway. And this is a standard driveway that you'd have at a shopping center or any, 24-foot aisles, 9 by 18 parking spaces. So, I don't foresee there being a problem, but I'll double check it again.
Okay, thank you. Okay, thank you. That's all I have for now. Appreciate it.
Okay. Justin, why don't we start down at your end and we'll work our way back?
Yeah, I think one of the things that I'd be interested, as Dean mentioned, is maybe having the sides match the front where you would see it from other spots of town. I did have one question on the lanterns, where you said that you investigated them further. Can you just give me a little more detail on that piece? I didn't hear it.
We originally picked a lantern that was close, but not the same make and model as on Sparta Avenue. And then it happened, we have a lighting consultant that came into our office and we showed him a picture. He said, give us that light. And that's what we put on the plans. And, I didn't get the spec that you have in town, but if it's not the same light, it's very, very, very close.
Okay.
I don't think you'd notice the difference.
That's all for me now.
If I could, I just want to make sure you got answer to the question. So the question I thought I heard was, would they be willing to do something to the sides and the back to match the front? And I'm not sure that I heard an answer there.
Don't know the answer yet.
Okay, but you'll be considered?
I'll ask the question.
Thank you.
Yeah, that's what I heard. I think they were going to ask and come back to us on that piece. Yeah.
Okay, thank you.
All right. Well, most questions I had have already been asked, but I do want to go back to one, when Mr. Bometti talked about the fire department, the fire truck. Just to make you aware, what the fire department's concern is a ladder truck, and which is certainly necessary to get up there with a 4-story building. And that truck is 40 feet 7 inches long with a 19-inch wheelbase. So I think it just needs to be confirmed that can make that curve and not get stuck. I understand the roadway's standard width, but there is a pretty sharp curve at the top. So that's it.
Okay. Just general statement, I'm not worried about the curve at the driveway. I worry about the curb at the islands. I have no problem with the truck getting up there, but we'll double check that.
Christine?
Couple of things, burning questions I have. One is that if I got this correct from Ms. Sarmad, there's a trade-off that goes on if you, in this particular situation, if you own 4 units, then you can have 60% impervious surface. Is that what I hear is happening here, based on this particular development and the apartments?
So yes, they have, part of the incentive ordinance is that if you offer 15% of the total units as for sale, then you can receive this, bulk incentive for the impervious.
Okay, thank you. It seems very harmful to have that, because what you're doing is you're degrading the environment there, and I mean, having 4 owners is no different than having 4 renters. You're still going to have the same impact on the environment. But, we're waiving a standard of 40% for that. So I don't get the connection. Maybe somebody else gets that connection, but I certainly
But
don't.
I
It's
think,
for the community.
if I could, the ordinance allows a certain impervious coverage that says if you offer for sale, you get this allowance. And I think the application, the way it's submitted, and correct me if I'm wrong, is they meet that requirement based on providing the 6. So it's a question of what's the requirement? Do they meet it? I believe the answer was yes.
Yes, no, I just wanted to make sure that I was understanding something that didn't meet common sense.
It's also the affordable housing units
Oh,
are built in.
affordable housing, that's great.
Yeah. That's linked into the same incentive.
Yeah, I'd recommend you read through the whole incentive section, the 8.5. It offers incentives mostly, like as Mr. Blumetti just added, for the creation of affordable housing. It allows for additional like mixed-use office space as a result. It allows, as long as the trade-off is supposed to be that you're allowing for more affordable housing to get developed, because this was part of in our settlement agreement, in our housing element fair share plan, the town center zones were included for the creation of affordable housing. So while I think that it probably will have, or, isn't friendly to environmental standards, it was supposed to help capture the affordable housing requirement that the township was facing.
Right, so now what I'm seeing is it's kind of a balance between social justice and environmental justice.
But if I may, maybe I could put you at ease a little bit. Although there's an 80% requirement, what the impervious coverage that exists today as a result of the footprint of what was there is 56.8%. What's being proposed is 59.4%. So basically, a 2.5% increase. What was previously approved by the board with the 70-unit project was 68.1%, which is roughly a 9% decrease. So in terms of, we're not maximizing the coverage as a result of the ordinance. We're actually reducing it from what was previously approved and slightly increasing from what is there.
Yeah, I appreciate that. I guess that makes me feel a little bit better. The other thing that I wanted to just bring up, I'm looking at the storm drainage, number 8. And I found it very unusual that you would have underneath the pavement, you would have the runoff being treated. So that's what will be going on in terms of the stormwater runoff, because I'm used to seeing all around our area drainage basins. So I tried to check this out and see if both water quantity, which you stress the water quantity reductions are being met, but also the water quality that goes into the recharge aspect. So because that's the most important thing, that's what being released into the soil layers is improved.
Yes, we are meeting the requirements. There's new treatment systems that come out all the time. We have a aquaponic type system which has filter media in the underground chamber, and the water flows through it and is cleaned. And there's a maintenance schedule that has to be done. So the DEP, this is certified by the DEP to meet their standards.
Okay, that was my next question then. All of that's going to be collected underneath the surface there in traps or whatever, and then you're going to have to remove the asphalt or the pavement in order to clean
No,
it
there's manhole
periodically.
covers. People will go in and maintain it and bring it out. And that's why the maintenance, the part of our stormwater report is a maintenance manual that gets recorded with the deed so that everyone knows what the maintenance is. It's not forgotten. So that's recorded and the maintenance schedule is published. Yeah, that's very important.
All right, thank you, that's all.
You're up. Mr. Callisto, thank you for your patience while you're answering our questions. Can you go through the traffic pattern of the parking lot? Are there going to be one ways, both ways of your lot?
All aisles are two-way,
All aisles are two-way. Okay.
all two of them, well, on the side.
If I'm living in the left half portion of the apartment building, yep. Is the expectation is they're gonna walk out the front door, instead of the side door, and then walk all the way around that sidewalk to the amenity area?
Oh, yeah, well, look, chances are people walk right through the sidewalk. I mean, right through the parking lot. It's not that there's a lot of traffic. So they could walk through, or we've got the walkway to go around it. If you were in a wheelchair or had a baby stroller or something like that, we provided a handicap-free route to get to the park, to the amenity space. And I mentioned there's also little amenity areas on the front of the building.
Right, but if you're gonna have let's say, a barbecue in the summer, you'd have to go to the amenity area on the other side of the parking lot.
Right now.
What's that?
No, as shown, yes.
The problem I'm having with, and Catherine pointed it out before, master plan amendment, town center development design guidelines, the parking lot should be designed to avoid conflicts between vehicular and pedestrian traffic. I'm having a hard time imagining that if I'm in one of those far left apartments, I'm not gonna use that sidewalk. I'm just gonna cut across the parking lot. And the distance of 150 feet or whatever, 145 feet, it just seems out of the way and not conducive to being utilized by the tenants. I was just wondering if there's a way that you can add a second side, if you're gonna leave it in that location, to add a second sidewalk on the other side of the parking lot as well.
I can look into.
Is that, excuse me, is that a very steep hill from our left corner of the building down to the sidewalk? Is that very steep there?
It gets that way, and we'd have to do some grading. If you recall, when I said when we took a couple parking spaces out of the middle lot and brought it to the lower left corner, we had to put a little retaining wall there. It's only 3 feet high, but beyond our parking lot, it does drop down.
Okay.
Like I said, I'll look at it.
Okay, sorry, Bill.
There was a couple statements about the easements along that would prevent from having the continuous curb cut. If there are easements already, why was there any kind of discussion about the tenants being able to use that part of the driveway to get back from the school? From dropping off the kids at school?
The easements were created years ago, and they only provided for the driveway access for the two properties, which was the Burger King and the shopping center. It didn't really address what was occurring on the site years ago because it was I believe, the motel and then assisted living. So there were rights that were given, but no corresponding rights given to this property. It just allowed that access to that driveway.
There seems to be conflicting testimony, and you'll have to correct me if I'm wrong about Mr. McNerney's testimony from, I'm not sure if it was the last one or the previous one, and your testimony tonight, Mr. Callisto, about the tenants. Tonight, you said statistics would indicate that you would have families in the apartment building. And then earlier, I'm not sure which one it was, I apologize. The indication was that the tenants would mostly be young professionals, divorcees, or do you have more accurate statistics of who would be living there?
Statistically, when you look at the school children, you look at the Rutgers study, which is basically one child for every 6 to 8 units. So statistically, that's what would be there. Real life in certain locations, you find that there are less school children. However, I believe, and I don't know if Mr. McNerney said this, it's typically the affordable units which would generate school children. But if you look at it statistically, if you did an impact statement on it, they would go to the Rutgers study, and I'll allow Mr. Burton to answer the question exactly, so I'm not testifying, but I just wanted to provide the clarification.
And that's what's in the environmental impact statement is the Rutgers study to generate the school-age children. And I'm thinking it was 11. I think that's the number. I don't remember, but it's something like that. So it would be all different grades. But what Mr. McNerney said is what happens in apartments. You have newly single people and professionals and young professionals and retirees, but you also will have some families.
Okay, I've just got a few questions. First, I wanted to really, I guess, second, support Bill's thoughts about having a sidewalk coming out of the other side of the building that would go from, I guess, like the left side of the building out to the sidewalk. I think there's going to be a lot of traffic there, and that would avoid the need for students to have to walk through the parking lot to get to the sidewalk. They could just exit the building, come along the sidewalk to the left, and then just have a walk that goes right to the sidewalk and connects it and avoid that whole thing.
Yeah, if we were to come out on the left side or the Sparta
Yes.
Avenue side and come down, and we want to connect closer.
Or you could even almost follow the arrow that's there. It could even be
Yeah,
a short.
but we just have a staircase here, and then the handicap access would be the long way around. But yes, we could come out and put a staircase down that hill easily enough.
Okay.
Cut 150 feet off the walk.
And then, looking at the sidewalks the way it is now, and I had a hard time seeing it, I missed it on the drawing, so I apologize, but, so if I look at the drawing, it's up there now, on the far right-hand side, along the side of the parking lot, there is a sidewalk there that connects to the building?
Yes, along it says 4-foot sidewalk.
Ah, okay, thank you. I missed it, my apologies.
Well, that's all right.
Okay? The other concern that I just want to talk about a little bit is the one loading space. I know that you've testified you feel that the one is sufficient. So let me ask, I probably should have looked at the Captiva. Do you remember how many Captiva had? It had one? Okay, and your other buildings of similar size, how many do they have?
Bob can testify to that.
Okay.
Some have none, and others would have one. It really depends on the size. We just completed a 250-unit building. I believe it had 2 loading spaces.
Okay.
Which it's not unusual, but Bob, why don't you come up and answer the question?
Or you can answer it when it comes up later, too. That's fine. Let me see, there was one other one. Will you be talking later to the size of the community room?
Yes, we're,
Okay.
once we break, I'll speak to the architect and client.
Okay, that's all I have. Thank you.
I just have one quick question. Can you show me where the fire hydrants are, please?
Well, right now, I see one, it's over here by the trash enclosure. There's a fire hydrant there. I think that's the only hydrant we have. Is right here, because the water's coming up from the street and we have a hydrant there.
Could you just describe in words where you're pointing?
Oh,
to?
I'm pointing by the trash enclosure, between the trash enclosure and the building, we put a fire hydrant.
And yeah, it would definitely be important to make sure that the fire trucks can get around to that space.
Yes.
The truck we use, which is a little smaller than what was described, can get fully around the parking lot, but we'll look at a larger truck.
Thank you.
Okay, any other questions on the dais?
Just if I may, Mr. Day, the fire official or the fire marshal did raise the issue with location, and we indicated we would comply.
Thank you.
Okay, if we could, I'd like to open it up to the public for, if they have any questions related to the testimony that was given tonight.
Hi, Vivian Perlmutter, 5 Morgan Drive.
Vivian, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
I swear.
And please spell your last name.
Perlmutter. Is there any ordinance after the unit is purchased to prevent the person from then renting it out? In other words, if it's a purchased unit, is that like a covenant into the apartment?
No, technically, in New Jersey, that can't be regulated, but the ordinance does require that 6 or 15% of the 40 be for sale.
Okay, so the owner could then
Yeah, so
buy
you're-
them and rent them out?
That is correct.
Okay.
But that's because the state of New Jersey prohibits municipalities from regulating either condominiums or rental. It's actually 2 statutes, the Municipal Land Use Law and the Condominium Act, thanks to our great legislature, totally prohibit that.
Okay. It was interesting that you people brought up the townhouse development at Mara, which is right next to the bowling alley. And if you've ever gone there, I've gone there several times, and it has a beautiful entrance, just like most every development here in Sparta. Previous planning boards always insisted on lovely entrances. Just drive to Sparta Commons, where they even have a bus shelter for the children. Drive over to Mara. You can come, I'm in Sparta Chase. I can swear to you that none of these developers wanted to spend a whole lot of money on an entranceway. They all wanted to do it as cheaply as possible because they want to make the biggest profit possible. But the planning boards that sat where you were sitting previously insisted that Sparta must look good. That when people came to a place where people lived in Sparta, that it would look good. And it's not, the proposed entrance does not look good to me. And I really, it hurts me to think the property values of a town depend on whether a town looks charming, really. I hate to think that looks matter so much, but they do. And you have to know that previously, our history, our planning boards insisted that anyone who wanted to develop a property here in Sparta had to pay the extra money to make a beautiful entrance. Just drive into Sparta Commons. It looks lovely as you drive in. And we have to keep that up, or everything sinks in the town. Previously, I lived in Parsippany, and I saw how things went down, down, down. And it only stays good if you insist on it being good. So I'm asking you to have some courage and assure you the Toll Brothers never wanted to put a dime into an entranceway. They shaved every penny off of everything, and they never would have done it if the planning board hadn't insisted on it. People do what they have to do. And please have courage. Thank you.
So, Ms. Perlmutter, if you could, before you step down, I just want to make sure that people understand. So this portion of the question of the public comments, it's really questions directed to the applicant.
Oh.
So is there a question along those lines that you would like
Then
to ask the applicant?
is there any way you can beautify this entrance? You're talking about a road, you're just going to pave it. What about the plantings next to it? The signage is going to matter. Everything's going to matter. People don't want to drive up a Burger King entranceway into a housing place. It just doesn't have any charm.
We have so much real estate, we're limited. We don't have a lot of frontage. We are improving it, we're paving it, we're putting street lanterns up the entire driveway, and we're putting a sidewalk in. And elsewhere, we are planting lawns or vegetation where there's no sidewalk. We had not, we are improving it to the extent we can. If we had more real estate, I'd make big sweeping driveways, but I don't have that real estate.
Well, and there's no way to buy anything along the bypass and come in that way.
No, not.
Thank you. And again, to just other members of the public, if you could, direct the questions to the applicant and, opinion type questions. We want to hear your thoughts. We want to hear everything that, all those opinions. But that would be later when we close the testimony and you have a right to comment and provide your opinions. This portion is supposed to be really questions to the applicant about the testimony they've given tonight. All right, thank you.
Thank you. Margie Murphy, 9 Pueblo Parkway.
Ms. Murphy, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
I do.
And please spell your last name.
Murphy.
Thank you.
Yes, I had a question of where, with the redesign of the facade, where did you look in Sparta and what kind of architecture would you consider that to be? That would match a Swiss village?
I think we have to get to the architect next for that answer because neither of these witnesses really are architects. So
Okay.
maybe focus on any questions for Mr. McNerney or Mr.
And the busing and the children that come down there, that really is not a huge area. And also, there's a pot store right there that the children are going to be coming down and being picked up in the bus that you may want to think about maybe having a bus up there because having kids dropped off in front of a well-known pot store is not really ideal. Then I'll wait for the architecture. Thank you.
Mark Scott, 9 Pueblo Parkway, Sparta, New Jersey.
Mr. Scott, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
And please spell your last name.
SCOTT.
Thank you.
Last time you gentlemen were here, when you were out in front of the building, you were talking about how you would just buy the units and rent them out. But according to New Jersey law, deed restrictions for affordable homes include but are not limited to the following. The homeowner is required to live in the home as their primary place of residence.
There's no question, Mr. Scott.
Which is defined as residing in the home at least 260 days out of each calendar year.
The-
Do you
the affordable-
anticipate complying with that?
The affordable, yeah, the affordable housing is different. The question previously
No, this
raised.
is about affordable housing.
No, I know. The statements about the sale units are not affordable units in this development. The affordable housing requirements of the state of New Jersey of COA rules and of UHAC rules will apply to all of the affordable units. There will be 6 affordable rental units, and they must comply with the DEP, with the DCA and UHAC. It's actually the New Jersey Mortgage Finance Agency, which you're probably familiar with, the rules for deed-restricted affordable units. So if you want to ask a question, please go ahead, but we're not allowing them to violate the
There
code.
seems to be some confusion here. Are these COA units, Ms. Sarnad said they were for sale.
No.
Mr. Collins says they're not, and you're saying they were for sale. Are they for sale or are they for rent?
Well, everything you just said is not accurate. And what Mr.
Everything I just said?
Everything you just said.
Okay.
Mr. Collins indicated before, when this was being discussed with the board, this is a 40-unit project.
Yes.
15% of those units will be rental affordable. 15% of those units will also be for sale. The for sale are not the affordable units. Under New Jersey law, based upon COA regulations, to the extent those regulations are still in effect, require that they be deed restricted for a period of 30 years. But that's 6 units. That's not the entire remaining 34 units.
What he just said, Mark, is correct.
Okay.
Maybe the uncertainty was that the confusion is there are 2 different 15%. One is there have to be 6 for sale units if there are 40, and the other is that there must be 6 rental affordable units. And that is a good thing for Sparta because rental units in COA rules achieve at least under the current COA rules, which are changed as of today, provide 1 bonus unit or 1 bonus credit for every rental unit, so that 6 rental affordable units equals 12 affordable credits under the COA math, let's call it. But they are 2 separate things that we're talking about. 6 for sale units and 6 affordable rental units. The for sale ones are not affordable. The 6 affordable rental units are rental only, and they do have to comply. They have to have a deed restriction. That's in our ordinance, that's in the COA rules. It's required in the UHAC rules as well. So, and that is checked and implemented and must be complied with going forward for the 30 years, and sometimes there's a way to even extend those 30-year restrictions and try to obtain additional credits after the 30 years expire because they've been expiring in various developments throughout New Jersey.
Are the for sale units going to be all in one area, on one floor, or are they going to be scattered throughout the building? you indicated that you were going to put in a tank to improve the water pressure. And then you also talked about how the water to fight a fire would come up from the Sparta Avenue. And I just wanted to know if would the tank that's going to increase the water pressure, will that be available during a fire situation?
Well, there would be a fire pump inside the building for the sprinkler system. That would be there, and that would be part of the purpose of the tank. As far as fighting a fire, we'd have the hydrant there, but that's part of the mechanical design and working it out. The intent that there's a hydrant there, it's got to work, and it's got to meet the fire code. So that's another agency beyond this board. That's the intent of the project.
So the water pressure that you were speaking of primarily is to increase the water pressure for the tenants, is that correct? Or no, or is it for a fire?
Well, the primary one would be for the fire, but it's got to have 20 PSI at least for the tenants, but we need the fire suppression system. That will be reviewed by the building department. And that has to meet their requirements.
Okay. Why do you believe that the Rutgers study applies here when we calculate our student calculation? We previously had a project called North Village here, and the developer came in and told us that there was going to be less than 20 school-age children there. Now we have 180 children there, and we are building a new school. So why should we believe that there's going to be 11 kids? When obviously the last developer, or the developer I'm speaking of, was wrong by a multiple of 9.
Well, I don't know what he based his counts on, but this is the guidelines that we have to go by. It's not something that I'm going to make up or a planner will make up. We have guidelines to use.
I mean, we have a very good school system here. We have a very good community. People move here for the charm of Sparta, and I just can't believe that it's just going to be 11 kids. Are you going to stick with the 22-foot parking space size? You're not going to come in and ask for it to be knocked down, right?
Parking's on the plan.
Right, and you said it was 22 feet, didn't you?
No,
18?
aisles are 24.
The aisles are
spaces
24.
9 by 18.
Okay, 9 by 18.
9 by 18 or 9 by 20?
I'm going to say 9 by 18. No, they're 9 by 20, even though we can make them 9 by 18.
No, don't make it 9 by 18. Only certain developers in this town get to move it down to 18. Okay. And then we'll be able to talk about the outside exterior design at a later moment. Thank you.
I think they said they would address that, yes. Any other members from the public?
Adrian Meerman, 12 Brook Drive.
Mr. Merriman, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please spell your last name.
Meerman.
Thank you.
I have a question for the engineer. The last question of the previous meeting had to do with the car-dependent nature of this apartment building. There was a question asked by a lady, like, is this a car-dependent development? And the answer was yes. In this part of the state, the cars really are an important part of the infrastructure. Do you remember?
Yeah. Okay.
Here in Sparta, we've been trying to make the town more walkable, and you respond with sidewalks along the roads. And you have responded with a sidewalk along the drive, which is a 4-foot wide sidewalk along the north side of the driveway. Now, 4 feet is not enough for more than one person across. So in Sparta, what we have is a 4-foot sidewalk and a 3-foot buffer area, if you will, with pavers. So we have 7-foot sidewalks. People can walk safely and feel that they're not just scurrying along a road, but that they have a true opportunity to walk from A to B. Is there any way you can expand the sidewalk capacity on your plan to make it conforming to the general standards we have in Sparta?
Well, we'll look at that. I think you might be referring to like often there's 3 feet from the curb, and then the sidewalk is beyond that, and in that 3 feet, you could put the pavers. We have the sidewalk up against the curb. We'll look at it.
Okay, how would you look at that? Is the current driveway, is that the same road bed that you're going to use for your new road, or do you have to widen the road bed?
Well, the sidewalk is beyond the current paved area now, so we are widening it to get the sidewalk in. We are increasing the impervious coverage to get the
Okay,
sidewalk.
right, so you'll be cutting into the hill in order to create the sidewalk.
Correct, that's why we have a small wall. There's remnants of walls there now, but we're putting a wall in order to get the sidewalk in.
All right. Now, as that sidewalk goes down to the area near 181, where at one point there's going to be a lot of shared pavement between cars, between the sidewalk or the sidewalk connection to the sidewalk on Route 181. You mentioned that the paint there is worn away. You would refresh the paint in order to make it more clear that which part of that pavement is meant to walk on, and that cars would not think that that is part of their roadway.
No, well, they don't. Parallel to the curb on Sparta Avenue, and a little bit off the curb would be the crosswalk where the sidewalk would be, which is roughly 3 feet or so, or begins 3 feet or so from the curb line back. The pavement stripes have worn out, and we will restripe across our driveway and into the shopping center driveway to the north of us.
As a design solution, also a safety solution, the engineer, Mrs. Fernand, alluded to it, that one of the concerns is that there's no clear separation of the use of a certain piece of pavement. Is it for cars? Is it for pedestrians? It's a mixed use, essentially.
Right, it's a crosswalk, so it crosses a driveway.
Correct. So I'm going to continue at that point. So the crosswalk can be done with a paint which is going to wear away, or the pavement of the sidewalk can actually continue and be a much stronger visual reminder that pedestrians have a right-of-way, that they can walk there safely, as opposed to pedestrians crossing a road. You would have cars respecting a continued sidewalk that they have to cross with a little platform to get to, say, the parking lot. Would you consider investing in that kind of solution that we see spring up around the country, and that I think would be very good for your project?
Are you talking about like a speed table where the sidewalk is high?
It could be right. The sidewalk could be a speed table.
Yeah, given the constraints, we're in a tight area. I don't know that it'll work. I'll take a look at it, but we have to meet the driveway next door. We'd have to. No, I don't.
According to your drawings, it will work. So yeah, please look into that and report back to us. You invited us last time to visit the site and to see how wonderful the site is, elevated above the town and the views and so on. So I went there. And I looked specifically at the trees, which are mature and are in very bad shape. Those trees look very stressed. They have been covered in vines for years, if not decades. And when I look at similar trees on my own property, they're dying one after another. So currently, we have a site with mature trees, but I would say there's absolutely no guarantee that in 5 years, any of those trees will still be there. So my question for you, as far as the landscaping goes, at what point will you begin to fill in those trees that you must take down in order to always have a mature growth around your building?
I mentioned at the onset of the hearing tonight that we added shrubs or evergreen trees on the plan.
Correct.
To fill in.
Correct.
So
And so my question is, relative to breaking ground for the building, when will you start the landscaping so that we don't end up with a situation where trees, all the mature trees die off and new trees will take forever to grow to any appreciable size?
the landscaping has to be installed before the building can be occupied. So it has to be put in.
Has to be put in. When do you plan to break ground?
Yes, it could be at the end of this, later on this year if we get all the approvals.
Okay. Oh, yeah. A question about the roof. You have a parapet wall as a visual barrier to all those split units, heating and cooling. I couldn't quite tell from the drawing, what will the material be? Will it look like a roof, a mansard roof, or will it look like a wall that goes up to the current
Well, the
height?
architect will answer that, but right now a parapet is a straight wall. It's a
Sure.
continuation of the wall below, above the roof. So, but the architect can answer that better.
Okay, excellent. There was a very brief mention of the split units, heating and cooling. How many such units will there be? One for each apartment?
At least, yes.
Okay. There is a concern about the noise effects of those units. With 40 units that may end up in harmonic amplification of each other. They're all humming on at the same rate. And the sound really spreads from that highest point in Sparta all the way across the White Deer Plaza. During the daytime, you may not hear it as much, but in the evening, when sounds really die down, that may become an actual source of noise pollution.
Jump to your question, they will meet the noise ordinance, so they will not carry beyond the property line.
That is,
There's a statewide ordinance about noise levels.
about noise levels. And then one last question I have. It was not covered this time, but you mentioned it last meeting, and that is about the electrical supply to the building. Nothing was mentioned about it tonight. In the February meeting, you mentioned there was a utility pole from the street leading to close to the property line that you would tap into and lead cable to your building.
Correct.
Okay, I'm just wondering if that pole would have enough capacity to carry an additional 40-unit building with very high electrical requirements.
Yeah, the utility companies know how to handle this. Yes, it would be high voltage.
Oh, they know how to handle it, and if necessary, they will, I'm sure, increase the cables. I wonder if that is something that was at all part of the application, that it would have an effect on the appearance of 181 if different kind of poles need to be brought in to handle the capacity required of the building.
The answer is no. No new poles would be put on Sparta Avenue. Absolutely not. We'll carry with the poles that are there. As a matter of fact, there are poles that go back to the property that served the building that was there before. So it would just be from Sparta Avenue moving into the property where we would have a couple of poles and then we would go underground when we get to the bend, the first bend in the road.
And, okay, fine. And so then from the pole to the building, it will be buried underground?
Correct.
I hope that you find a solution for the amenity area, which is a concern of the entire board. And I would like to join the concern that the amenity area seems to be only to check a box on the application. And it has, I don't see how it fulfills any kind of function in how people live in that apartment building. I hope that we come up with something more creative. If you want to hear something from me, I'll have some ideas for you in the break. And that's it for right now. Thank you.
Thank you.
Good evening, Jennifer Derricks, Tap into Sparta.
Do you swear affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
I do, thank you.
Please spell your last name.
Dericks. Could you please explain a little bit more in detail the easements, the curb cut easements? Who has the easements? Who are they being given to? How does that work?
They exist in title. They are to the benefit of the adjoining property owners, one of which is the Burger King and one of which is the shopping center. Those easements have existed for an extended period of time, and it runs with the land. So if there are any transfers of the property, those easements will continue.
Certainly the drive-through window is understandable. The other easements were addressed in the police report, in the second police report created by Corporal Morris in February, where he opined that that would be illegal to have traffic directed into the back of private property. So you're saying that that's not the case?
I can't speak to what Corporal Morris has said or what.
It's in his report to you.
Can I finish answering?
Certainly, thank you.
Thank you. I don't know what was in his head. I read his report. These are easements that exist. He cannot alter the legality of those easements because they are a matter of public record, and those property owners have the legal right to utilize the properties. I can't speak to the intent of the easements because they were created years ago, and neither can Corporal Morris. Corporal Morris did not look at the traffic report because it's not indicated in his short report. We may not like the configuration, but that's what has existed and unfortunately has to remain to exist.
I can tell you that what was in his head, because I did ask him, was safety. Thank you.
I'm glad you're going to tell us what's in Corporal Morris' head. You can ask a question but not give the board hearsay.
Sure, well,
Once
okay.
Corporal Morris here, they will ask him.
Wow, okay. Thank you for being so kind. The other question was,
Chairman, could we do without the editorializing here? If there's a question
That would be
on the
nice.
table, we would put it on the table.
So if I can, I want to bring the level down. So again, so the purpose of this portion of the discussion right now is not to comments unless it's followed up by, for reasons of setting up a question.
My apologies.
But it really has to come down to a question on the testimony that's been given by the
I
applicant.
appreciate that.
And comments, again, we want to hear them, but we'll open up the floor to that later.
Thank you. You did indicate you had photos of buses and a report from the Board of Education Transportation person. Would that be something I would need to Oprah, or will you be willing to share that?
That is not correct. We have an email between my client and the Board of Ed, and we have pictures that were taken at the site.
You can ask them to produce it, Ms. Derrick. You're You're now cross-examining someone, and you can ask them to provide it as an
Mr.
exhibit.
Burton will provide the pictures tomorrow morning.
Thank you, I appreciate that. Wonderful. Thank you for your help. That's it for tonight.
So we have to make them an exhibit, sorry, Jen. They're now I believe it's A3. Okay. A4, we're up to A4. Why don't we make all four, what is it, 3 pictures? 4?
Actually, there's 2.
Okay. So how many?
There are 2 photographs, so we're at A3 and A, were we up to A3 or?
A4.
A4, why don't,
So that would be A4.
make them A4, maybe Mr. McNerney could just identify them. He produced them just now, so we'll mark the back A4A, A4B, and A4C. You might want to, Mr. McNerney, when you produce something, you have to say you took the pictures. You identify them as your pictures you took. So if you just come up, okay. Why don't you use these, because I marked the back, and that way we'll know what A, B, and C are without too much explanation.
These are pictures I took 2 weeks ago at the bus stop during school hours, during the pickup. And A4 shows the view looking down Sparta Avenue. That would be in easterly direction, I believe.
Look on the back, it's A4A or B or C?
A4.
Oh, my writing isn't clear enough, huh?
A.
I think they're,
Oh, A4A.
A4A.
I'm sorry.
I'll show that to Ms. Derrick, the one who asked me to produce these.
The other,
Now go to the next one. Identify what this next one is, A4B, I hope.
Fortunately, that's a duplicate. So.
okay.
Okay.
Be A4B.
Okay.
That's A4B.
Thank you.
What does A4B show?
A4B shows the bus from across the street in the parking lot of the shopping center. Clearly shows the bus sitting there with the driver, has the yellow vest on.
Is there a third photo, or was the third one a duplicate?
A4C is a head-on shot of the bus sitting in the parking lot.
Okay.
Thank you.
You're welcome.
There's
So,
also a reference to an email, so if the applicant is willing to, can't really open the applicant, but if the applicant admits it as an exhibit for you to cross-examine Mr. McNerney, it can become an exhibit, which you can get a copy of as part of the record. Is the applicant prepared to produce the email?
You just have to look at the email chain, because the one that I have, I am on it, so.
Okay. So why don't you during the break, take a minute to see what you would like to produce in response to this question.
I do have a follow-up question, if I may, on these photos. Thank you for producing them. Did you, while you were observing the bus, and the bus driver has exited the bus, as you indicated, the gentleman or the person wearing the vest, did you observe students getting on or off the bus?
No, I did not.
Right, and also in the Burger King parking lot, in what you have marked as A4B, you'll see there's another bus there, and certainly there's not, that's not a bus stop. So often, what we'll observe throughout the town, during down times, the buses stop at different places in town. They stop at the Stop and Shop, they stop at the bowling
You're
alley.
not testifying, so that's for the
I'm asking if, okay, I apologize for testifying, but I'm just saying that this doesn't necessarily indicate that this is where children get on and off. as was stated, and the bus driver has exited the bus, which doesn't seem to me to be a bus stop.
Well, you're absolutely wrong, because I spoke to the Board of Ed. The Board of Ed advised me to go to the high school to talk to the transportation boss there.
She resides at the Mohawk Avenue School.
Excuse me?
The transportation director is at the Mohawk Avenue School.
Let's give.
Okay, I'm
a
sorry.
chance
Go
to
ahead.
answer.
And I asked the lady,
June. Mhm.
June Macco, if in the event we have school-aged children living in this building, should it be approved, where would they get the bus? And she said, 55 Sparta Ave.
Right.
Okay, now, after that, the next day, I went to 55 Sparta Ave to verify that, which those pictures depict.
If that's what you think, that's fine.
Okay, are there any other members of the public? Okay, so typically, we don't start new testimony after 10 o'clock, but I think we need a break. So I'm going to recommend that we take a 5-10-minute break and then come back and maybe we'll start the architect that is here tonight. I know we have a lot of applications backing up behind us, so we really need to try to get through this. So, any feel for how long the testimony will take? How long?
I do not know yet, but why don't we take the break and see where we're heading?
Okay, sounds good. Thank you. All right, 10 minutes, everybody. 10 after, we're back.
my client, apparently based upon their experience, we believe the amenity areas are sufficient for this number of units. Mr. DeToli will go over the amenity spaces, and again, and also the design, so hopefully we won't take too much time.
Okay. Gonna try, okay, let's just go and see where it goes. Thank you. Is it just the amenity space that he's gonna cover, or the
The amenity and the
architecture? Okay, okay.
Mr. DeToli, you understand you're still under oath?
Yes, I do.
And please state your name and spell your last name.
Albert Dottoli, D as in David, A, T as in Thomas, T as in Thomas, O-L-I.
Thank you, Mr. DeToli. Please go ahead.
All right. Al, since the last meeting, you provided a redesign of the building, correct?
Yes, that is correct.
I'll give you the mic in a second. And before we get to the rendering, why don't you tell us about what the amenity space is and what's being provided within the building?
Within the building, we have 3 community rooms, one on the second floor, one on the third floor, and one on the fourth floor. Those rooms are approximately 320 square feet each. We have an exercise room, which is approximately 600 square feet, and that's on the second floor.
And that design was done in conjunction with the client, correct?
That is correct. The client is very satisfied. He is the company is a manager of 1,200 units. They are very, very comfortable with the locations of these rooms and the sizes of these rooms.
And why don't you tell us about the revised rendering, please?
So we've redesigned the front facade of the building. We looked specifically at the buildings in the Lake Mohawk area, the country club area, and we saw very steeply pitched roofs. The architecture there is somewhat of a blend of English Tudor with the boards and the stucco infill, and they also have there's a mix of different materials, some stone, some brick. So we use that as kind of an inspiration setting for this building. So again, we've added these steeply pitched roofs that emulate what we see in Lake Mohawk area. We've broken up the building. We have very significant vertical elements which break up the long 230-foot facade. On a vertical, in terms of the vertical breakups, we have railings at these balconies that help break up the horizontals or the vertical elements as well. We've added significant motifs or elements, features, these sunburst pediments, shutters, louver-type features at the peaks of these buildings, some dental molding in the cornice. We've added grills to the windows, again, to make it look more traditional as opposed to contemporary. We have, again, significant amount of features. These archways with trim work that enhance the look of them, railings with balls on top of the balusters. We have the bottom. We have in some areas some stone rustication, which is very typical of ancient buildings. You have a rusticated base, and then from there you move upwards. So we feel we really changed the look of this facade.
Al, in addition, the coloring that is on the facade will continue all the way around the building, the grays and the lighter gray, if I'm getting the colors even correct.
That's correct. They're a warm gray texture, color, hue.
But just so that we're clear, we're not going to have the fenestrations that are there with the peaks on the sides.
That is correct. As Mr. Burton testified, the only elevation that can be seen from anywhere is this elevation here, the front facade of the building, and it'll be visible from some townhouses that are across the valley. This side of the building, nobody will ever see. This side of the building, you can see as you drive up the driveway. The back side of the building, we're looking at woods. There's no view of that building from anywhere.
And just a clarification, Mr. Burton did speak about the parapet wall, the split units on the roof. Two questions. Will you see the split units? And number two, how many are there?
The split units will not be seen. We have a parapet wall that goes above the roof line. That parapet wall is approximately 3 feet high. The units are about 36 to 39 inches. When you're down below, you're looking up and you're looking over that parapet. These units are not near the parapet. They're more central to the middle of the building. The building is 55 feet deep, so they're in the middle third of that 55 feet. And I know there was a question about noise. These units are very high-tech units. The fans are very quiet. I did a building where we had a rooftop pool, and 25 feet away, we had the rooftop units. You couldn't hear them from 25 feet away. And this was during the summer when, if not all of the units were running, most of the units are running. And again, there is state statute that limits the amount of noise that can be produced, and that will be adhered to.
I have no further questions for Mr. DeToli, Mr. Chairman.
Okay, so Catherine, why don't we start with you this time in terms of questions, and we'll go to Dave next.
Sure. Thank you for the presentation. Can you confirm, is that a flat roof still?
It's what's considered a flat roof. It's a very low pitch, just to get the water to run to the roof drains, which are located in the center of the 55 feet.
So effectively, the other facade treatment, like what is on this front facade, the interior facade to the parking lot, the features there are just, they're decorative pitches.
That is correct. Well, they project out over the
They project
balconies.
over, so they're small roofs over the balcony.
Yes, that's correct.
The other elevations around the building would appear to be flat if you can see them.
No,
If
we
there was-
have hip roofs on those. They're peaked, but they're three-sided, like, consider a pyramid where you cut off the upper half of it. It's a hip roof
there-
on top of those balconies.
On the other elevation.
Yes, I think you have a rendering of, that was submitted previously.
Oh,
That was
okay.
the
So why don't
update.
you pull that out, Mr. Dotoli, and go over that, because
Yeah, I don't know what
It's on
happened.
the elevations, not.
Is that down under? Is yours?
Sorry.
Hold on one second. There we go. I think you have this rendering that was submitted last time.
Let me check.
But don't you have is it the same as your prior architectural elevation on your plan?
Okay, it's,
You're saying that there's a hip roof over the balconies,
No.
but
it's a gable roof. I'm sorry.
okay, a gable roof over the balconies,
Yeah.
and, but,
This is page A1 with the latest revision date of being 1/23/2024. A1 revision date, revision number 4, 1/22/2024. I
okay,
know we
so-
submitted those.
put that up on the easel, if you would, please, and let's go, like, I have to say, it's a little unusual to get it. I'm pretty sure the design standard requires you to use the same materials on all four sides of a building like this. And I respect that you're, to some extent, you might want the facade, front facade to be embellished something more than the side and rear facade, but quite frankly, they're not even the same materials, they're not even the same color. From what I can tell, they're not the same color.
Mr. Collins, you're stealing my comments.
Well, please go ahead. I like to get to the point of things, so, especially at
It will
the,
be the same colors. They are similar materials. We're talking about stucco and brick, and we have that on the front elevation as well.
yeah, but
We have gable
on
roofs.
the front
They're
elevation,
not as steeply pitched. They are arch topped on the gable roofs.
So just clarify for me, the elevations from the fourth revision, 1/22/24, the proposal is to change the front elevation, to what was presented tonight in the color rendering, and keep this architectural style elsewhere.
That is correct. That's our
I
proposal.
couldn't disagree with that approach more. I am in, I mean, my supplemental review included comments to say all 4 elevations of the building should have the same architectural treatment, the same quality of materials. And I could not imagine two more different treatments being added to this building. I appreciate that the effort was made to redesign the front, but I do think that an effort should be made to try and match those treatments, not necessarily, gabled balconies and things like that, and covered balconies, because those sides don't have balconies, but there needs to be some level of, design functionality and consistency.
This is our proposal.
Thank you. As beyond the outside facade design, did you have a chance to review any of the comments related to the interior programming of the building?
Yes, and I just testified that along with my client, we developed those community rooms and that exercise room. They are very satisfied. They feel that they are very functional for the use.
Okay, thank you. I have no further comments.
I did. Mr. Tolley, where's the stone on the rear side and,
We have,
the
we-
back.
we show brick right now, but
I noticed that, right? You don't show stone. I'm not sure the brick is the same brick as I don't even see brick on the front facade. Do you see brick on the front facade?
on the lower base, it's kind of hidden
Don't
by
see
the
it.
shrubs.
I see the stone,
Being-
and I think it's a good idea. But I don't understand why the stone doesn't carry around to the sides. Probably a faux stone material, right? But then it doesn't, but then there's no brick above it, is there? Clapboard. I presume it's hardy board or something like that, clapboard?
Stucco up above.
There's stucco above the stone? Why are there lines that go horizontally? Yeah, it's not acceptable.
Okay. we could agree.
I think we need to see, I think I think you're getting closer with the front facade. But I'm not even vote, they vote, and you gotta get 5 out of 9 to vote yes. But I don't think there's any doubt that the town center design standards in the ordinance, which reference a master plan, which reference pictures, which reference pitched roofs, means you gotta do better on the whole appearance of what is going to be a relatively flat roof in the middle of the building, but somehow you have to do something with your edges to make the roof of the building look pitched from all 4 sides. That's a requirement in the ordinance. And there are pictures in the master plan that help elaborate on that, but it's a requirement. So you've done something to help with your pitches over the balconies, but you're not carrying it through to the rear side. I mean, they couldn't be too different. I mean, you look at the rear side on your drawing, I get it, it's a gable, you're not even keeping the same pitch. You're using different balusters. I think you're using brick where you're not using brick on the front, which I think you gotta do better, is what I would say, and I think you can. Like, an example of a building that has a flat roof but has a facade that appears to be a pitch is the Sparta, I think it's 85 Sparta Avenue, it's the Medical Arts Plaza. It was built by a hospital, the Atlantic Health System Hospital. It has copper, faux copper, as a way to pitch the very portion that you're saying will just be a straight up and down parapet, to hide that there's a flat roof on in its case is probably much wider than 55 feet. It might be 100 feet. And you can't tell from the road what's hidden behind that faux pitch. This is flat across the whole length of 220 feet? And 55 feet in both directions. That is not carrying out the requirement of the ordinance that town center design standards in the ordinance require pitched appearance. Now, there must be some way for you to truly revise these drawings to be a little bit closer to the appearance of this front facade on all 4 facades. But when I look at your drawing, I see horizontal lines that look like clapboard. You're not proposing clapboard on this drawing?
And I think I can now answer that, Mr. Collins. I just spoke to the client. The materials will carry around the 4 sides of the buildings, but those, I guess, the protruding fenestrations will not. So the stone, the plank, the stucco will continue.
Okay. And isn't this color more of a beige than it is gray? I don't know how, I'm very good with color. And to me, that looks like beige.
Yeah,
So,
whatever, you have a combination of both.
but do you? I mean, I don't see gray. I
intention-
think I'm really good at this, okay? This is one of the things I happen to be very good at, is
The
color.
intention is warm grays around all 4 sides of the building. Some dark ones towards the bottom and lighter colors towards the top.
But this picture is your picture. I mean, I get it but I didn't print that. Printer printed it from your diagram. Even the one you put up today looks beige, which I think would be more in keeping with the character. Like, you're fighting over gray. I don't see any stucco on
If the preference is beige,
I think it is. I think it's more, much more so than gray.
We'll go with beige.
Okay.
If that's the board's,
I see beige. I don't know. I almost saw yellow and then decided it's not yellow because it's not Weichert looking. Okay, so, look, that's only one idea, but the point is, your very better, much better A1 is very different than your January 22 elevation in graphic. So I think I don't know, I'll defer to the board how they want to step forward with that subject.
You know, just hearing the discussion, you know, when I look at the materials we have, I'm not sure the materials really reflect what's being proposed. Because I'm hearing, well, it's really this, not that, and it doesn't show this, but it will do this. I think, you know, the last time that you folks were here, you promised that we get colorized versions of all 4 elevations. And I think we need that to see what it is you're proposing. Does anybody on the board disagree, or anything that you'd like to add to that?
I'd like to see clapboard on all 4 sides. I get it that you're gonna not be as fancy on the sides and the back. I understand that. Because you're putting a lot into the front there. But I think it has to continue the theme, you know, as far as the clapboard and the stone, all the way around the building.
And that is in I'm looking for it in the ordinance. It actually does say it has to be consistent on all 4 sides. Let me see if I can find it.
I just want to, I do appreciate the work in the front. I think it's come a long, long way. When I first saw this, you know, it's a big difference from what we saw originally. So I do want to say that. I appreciate it.
Yeah, so when I read from the ordinance, it reads, "The entire front, sides, and rear of the building shall be coordinated in compatible colors and materials."
If I may, Mr. Chairman, I think we're sick of seeing each other. But my client made a suggestion, is that perhaps if we can complete, if that's a condition of approval, we can certainly deal with that. I would also agree to withhold or extend time for a resolution if necessary, so we could provide that, because the intention is pretty much along the lines that I heard from Mr. Reichstad, that the coloring and some sort of design element will be incorporated on all 4 sides. You know, the front will stay as the front, the coloring will continue, the materials will continue, and we'll see what design element we could add. But I think that's what you're asking for, they're willing to do it.
So are you suggesting that you'll give that to us prior to an approval, or after?
As a condition of approval,
So
but
is
I
my-
would also provide it prior to the adoption of any resolution.
So the concern I have there, and I'm going to look to our professionals to help me out here, is, you know, it just seems like there's room for misunderstanding there. We'd like to see what it is that's being proposed, so we can have a clear view of what it is that we're either approving or not approving. So I really would like to see the 4 elevations in the final design.
So let me ask this question before I consult with the client. When is your next meeting?
So let's just talk. So with the next meeting, we're committed. What do we have after that, Dory?
April 17th, May 1st, May 15th.
17th, May 1st, and so if we could slide them in on the 17th, is that still open? Or is it,
Technically, but it's hard. We have a little uncertainty, but we can try.
so what about the 1st?
May 1st is maybe more realistic. Also, you should really do the drawings and
Yeah.
get them in at least 10 days before the meeting.
Yeah, I agree with that. You know, that was part of our discussion tonight we're going to have, is giving everyone a chance to properly review them. So
And I have no problem doing getting the drawings in before April 17th because it's a revised rendering.
Okay.
But I would also suggest, because we have certain time constraints, and again, I still need to consult with my client, but, you know, I look at returning and not spending a significant period of time. You either like the drawings or you don't.
We also have a few other issues to work through still, right? There's a conversation around going and looking at the property for wetlands, right? There's the amenity space. I'm not sure if we finalized that conversation.
I think for where we are, Mr. Blumetti, tonight, is that the amenity space is as it is. The wetlands, I will be able to address. I have no problem having the consultant look at it, but that's money for my client.
Also, the sidewalk and the steps down to the sidewalk and proof that the larger fire truck can fit on the curve, I think the curve of the internal parking lot curves, not the driveway, you've proven that.
My suggestion.
And we do really need to open to the public. so-
I understand.
Yeah, okay.
But the other suggestion is I think the sidewalk and the fire truck turning movement are more technical in nature. I do not intend to bring Mr. Burton back. I think we could submit a revised drawing with that information.
I guess you could try that. If Mr. Simmons was satisfied, that would probably,
Because there's not a lot to do. It's a turning movement and just the location of an additional sidewalk.
Yeah, but how about the wetlands? Isn't Mr. Burton going to be the person who says his wetland consultant did a
Well,
look-see?
we're not going to have that done prior to the next
What-
meeting.
Okay, why not? So, how hard is that? So,
Well,
I don't mean an LOI from the DEP. I
Right,
mean,
I understand. I mean, but, Mr. Burton can certainly submit a letter that somebody looked at it and that there was no visible appearance of any wetland, plants.
Okay.
Including adjacent properties that don't have a buffer that transfers onto your property.
That I don't know.
I understand, that's why I'm bringing it up.
I think you may need a witness. I'll defer to you how you want to deal with that, but that.
But I don't know if that is part of your ordinance.
It
It's
is
something-
it is a customary part. We sometimes make it a condition of approval, and maybe that's appropriate, but the way to solve it, one way to solve it, and not have to do a presence absence, is for a qualified wetland consultant to actually do the observation and present a report that says that there are no wetlands on the property or within the buffer area.
Give me 2 minutes.
It's like,
We will be back April 17th. We'll provide the rendering. I will speak to Mr. Collins about the wetlands consultant offline. We will certainly provide everything that we're going to resubmit 10 days in advance. We would request that we be carried to April 17th without further notice, and we will provide the extension of time for the board to act.
Thank you.
Thank you. So we'll carry the Plus Holdings application to April 17th, 2024 at 7 PM. and there'll be no further notice. Thank you, gentlemen.
Thank you, gentlemen.
Thank you, gentlemen, appreciate it.
No public comment?
At April 17th, public comment.
That's done.
My environmental report.
Yeah.
All right, get back to the agenda.
Yeah. Yeah. Okay, so if we can, I'm just going to move down to the next section. Okay, going to move to the next section, which is other board business. So we had, at the last meeting, talked about the possibility of having a resolution to enter into a professional services agreement for a traffic engineering consultant. There's been a lot of public feedback that they wanted to see more focus on understanding the impact of some of the traffic impacts of the development. So this is our answer to the public that we've heard you, and yes, we're taking these steps. So the resolution would enable us to sign that contract. So I guess the next thing would be, is if everyone's read it, to see if anybody wants to make a motion to adopt the resolution.
I'll make a motion to adopt the resolution
Okay.
for the professional services agreement
Uh,
with NEA.
With Negla. Tom, the resolutions, do we need a number?
No,
No? Okay.
but if Dory wants to give it one, she can.
Dory, could you just so we can keep track of the different resolutions? I know the first couple we did earlier in the year had some numbers.
Yes, we can do that.
Thank you. All right, so anybody like to second the motion?
I'll second it.
Okay. Okay, are there any comments from anyone in the dais? I'm looking in both directions.
I have a couple questions.
Okay.
The first one is around just understanding clearly what the use cases are for this. So in what scenarios would we engage this consultant to perform traffic studies? And, I'm thinking, in some cases, we get an application that already has a traffic study done. So is one scenario where we would ask this consultant to review and validate that?
Yes.
Yes.
Yes,
Yeah,
okay.
it's more,
That's
yeah.
primarily what they do.
Okay, okay. The
Because-
other one is where we get an application, doesn't have one, but we want one done.
Well, then we have the applicant do one.
Run,
Right.
okay.
So they would evaluate the traffic study the same way that Catherine and Dave evaluate the other information we get from the applicants.
Okay. Okay. I just noticed too, in the resolution, comparing it to the town council resolutions, typically there's a conflicts of interest clause in there or a
There
political
is.
contribution one.
This is a takeoff directly from the council's form of resolution and form of agreement.
Okay,
And the actual agreement will have that language in it?
Yes, it has it in it, and it uses the township council's version.
so I saw I didn't see it in the resolution. I saw it in the PSA.
Yeah, that's where it goes.
Okay,
The resolution approves the PSA, and the PSA is incorporated, the agreement is incorporated into the resolution.
okay.
So-
In the Article 15 in the PSA, it references contributions to planning board. It's all planning board centric. I didn't read it as,
They also signed the, Dory can confirm, but they signed the pay-to-play affidavit that confirms that they've made no contributions to any elected officials. as
okay,
far as-
okay. That was my question. Is
That's,
it-
it still has that as well, but it's in the paperwork attached to the agreement.
Okay, I just want to make sure it's extended to all
Yes,
the
it is.
council, elected officials,
Yes, it
everybody.
is.
Okay,
That's really who it applies to.
okay.
And you'll decide on a case-by-case basis whether you're retaining whether you're asking them to review a set of plans and a report.
Okay.
So it won't be every it would not be needed for every application.
Yeah.
The intent was, right now, Mrs. Simmons does a lot of these for us. So in the larger applications, or maybe on the more sensitive applications, that's where we would trigger these people to come in and help us.
Okay. Okay. That's all I have.
So is the roll call, I think we had a motion second, and we need a roll call.
Deputy Mayor Dean Blumetti,
Yes.
Jeanette Burke,
Yes.
Christine Dunbar,
Yes.
Vice Chairman Bill Enright,
Yes.
Justin Canellis,
Yes.
Celeste Luciano,
Yes.
Nick Pompilio, sorry,
Yes.
Ernie Reichstad,
Yes.
Chairman Ronde.
Yes. Okay, motion is passed. Okay, thank you, everybody. And again, special thanks to Ernie and Mike Sylvester. I know you did a lot of legwork to help get us to this point, so, and to Mr. Collins as well. Thank you. Thank the three of you very much. Let's see what else we got. Dave, do you want to just spend a few minutes just to give us, I know you brought something. I think people would like to see just a quick update on the maps.
Sure, Mr. Chairman and board members. You have to stand up because this map is bigger. My arms only go so far. The fellows at the office have been working on the zoning map. Can I go in? And basically, we enlarged the sheet, so it was a little more graphic friendly for everyone. And we included some inserts. There's an insert here in the upper left that basically has the delineation of the township, and it also has a delineation on it between the Highlands Preservation Area and the planning area. So it's a little more friendly as far as looking and finding what property is in what area. Then over by Tom's hand, we've got the color coding, and we also added some labels. The existing zoning map was a good map, and it had a lot of different colors on it. Sometimes the colors were a little tough to distinguish, so we put some labels on there so there was no question about it. In this little insert right here, it's kind of a unique area. It's North Village, and that's the area where all the different transects are. So we figured that'd be a good thing to have some information on when somebody's looking at that particular area. So we labeled all that involved. And then on the upper right, we've got the key map for the overall area where it is. So it's getting just about there. But again, between the bigger sizes and some of the insert maps, we thought it would be a lot more helpful and user-friendly to the board members and the planning department itself. So that's a quick update. So
Very much
just about
appreciated.
there.
That's awesome.
Looks
By
great.
everybody, yeah.
That's awesome.
Anybody have any questions or comments? Okay,
Just the final step would be, well, once it's finalized, it'll then be put online. Is that the idea of it,
Sure,
or?
this is all in GIS.
Yeah.
So it can be adapted that way, not a problem.
Okay, okay. That's great.
Just a quick update.
all right, thank you very much. A lot of good work, and we really appreciate it. So before we go on to updates, let me just check, does anybody have any other board business that you'd like to bring up that has not been brought up? Nothing down here? How about this side? Okay. All right, why don't we do the updates if we could, and Deputy Mayor Blumetti?
Yep, keep it really short and sweet. So 2 items. A meeting or 2 ago, we passed ordinance 2402, which was just regarding lead-based paint hazard inspections, requirements for rental units, just kind of relevant to what we do here. And the other one, just most of you know that we've been having conversations about short-term rentals, receiving public input in many forums, especially at council meetings, and doing some more legal review and considerations on that. But we're looking to revisit that again soon and get something out there as an ordinance in the real near future, given the summer rental season's coming up. That's it. Thank you.
Okay, thank you. Okay, Environmental Commission?
Yes, thank you. We have begun our planning, our first planning for our open space recreation plan. We've had our first sort of informal meeting, and we're organizing ourselves, and we're gathering materials and documents that we need to proceed. There will, I think I mentioned last time, there'll be 4 meetings, and at least 2 of those will require public input. And it is I think, the focus of our group to look at our open space with Green Acres purchases in mind. So we're looking for that. And we also need to work very closely at some point with the master plan committee, because one of the things that we'd like to do is to incorporate what we find into the master plan. So that we'll be working towards that. And then the sad thing is that our Environmental Commission Rain Barrel event is going to be canceled or postponed until the 13th of April because of the rain. 85% rain. Can you imagine how ironic is that, right? So we can't make the
You could
rain
test
barrels
them.
out there because it's going to rain. But they'll be doing it on the 13th, hopefully. The weather will be nice. Yeah.
Okay, anything else?
No, that's it. Thank you.
All right, I'll just do a quick thing on a couple subcommittees. Master Plan Subcommittee, we are meeting tomorrow night, having our second meeting. Plan Endorsement Advisory Committee, so I just want to take a moment just to, again, remind folks that at our next planning board meeting, April 3rd meeting, we're going to be devoting that primarily to a discussion on the plan endorsement process. What's it about? Why, why is it good for the town? And just, these are the things that we need to go through to get there. So this is one of our public sessions, so we hope to get a lot of folks on the public come out, ask questions, and just understand the process and see the benefit that we'll get from it. So hope to see a lot of people there.
And that is a joint meeting with the Plan Endorsement Advisory Committee.
Thank you.
And it will be noticed, and we encourage Jen and newspapers to publish the press release that Dory will send out.
Okay, and the minor site plan subcommittee, so I have stepped down as the leader of that, and Mr. Enright is taking that over. So, Mr. Enright, would you like to give the update?
Yeah, we usually meet for an hour before this meeting. We did not do that this week because we had another subcommittee meeting that didn't take precedent, but just scheduling conflict. So we did accomplish a few approvals over email, and we also are going to implement a new form to give any applicants so that they have a time frame and a window with dates on it, date received of application, date for an expected, 2 dates of an expected window between 2 and 4 weeks. Dory and Reisha have been doing a great job of trying to communicate the window of expected response, and we think this is going to be another step to help them do that. But yeah, we have a couple more to knock down, but we're pretty much staying within that 2 to 4 week window deadline.
Okay. Would you like to give an update on the grant, the working group?
Bill, go ahead. Microphone. You know, it's funny. I got 2 signs in front of me. One says speak directly in front of the mic, and the other one says don't touch the mic. So I don't know which one to listen to. The grant committee met tonight for the first time. The members on that committee are Justin, Jeanette, and Celeste, and Catherine also is going to be instrumental in helping us. She already made some recommendations on some of the other grants that she's familiar with from some of our other clients. The goal is to identify 1 or 3 grants to use for our municipal planning and some of the costs that are associated with that. We've identified a few already, and we should have an update on how many and which ones we're going to go after in about a month.
Great job. Great kickoff. Thank you. Anybody have any questions on the subcommittee reports? Okay, so now we're down to the next section, which is to open up to the public for matters not on the agenda and matters not relating to a hearing on an application for development. So would anybody from the public like to come up to the microphone?
Hi, Mark Scott, 9 Pueblo Parkway. I just want to thank you all for, really, tonight was probably the best night I've ever seen the planning board in action. It was just a great night. Tom Collins was there. You guys really held on. This guy was going to push us around. It's our town, and I really appreciate what you did for our town tonight. All 4 sides of that building, They have to look Lake Mohawk Tudor-like. Because, I mean, the guy said, oh, this side really doesn't matter, but this side does matter. This is the bypass here, and
Mark,
millions of people go that way, and, they should,
you could again, so now we're getting to.
Now we're
that was
good,
part of the
okay.
hearing.
Anyways,
It's a little-
thanks a
little
lot
too
for
close.
all your help.
But thank you, though, much appreciated.
Take credit when it's given.
Jenny Derricks. I also want to thank for the maps and the minutes. I just had a question about the maps. Will it include a designation or a notation about what property is owned by the township? That's been a question that's been coming up, and I anticipate that it'll continue to come up, not just by me.
There is a zone on there, I believe, open space and government owned, or words to that effect.
Okay,
So that may address a lot of what you're referring to.
I appreciate that. Thank you.
Yep.
Will we be able to get an update on what once it's synthesized and we have an understanding, an update on what the new COA rules mean? Do we expect to?
Yes, but the statute was,
I know, brand
according to
new.
the newspaper,
Yeah.
according to the TV, the governor signed a statute called A4 and S50 today. There's no longer any COA, which probably pleases some people, but in my view is probably a big mistake. Basically, their role is taken over by the Department of Community Affairs and some unusual arrangements with the courts. So bottom line is the answer to the question of when the number will be known is not clear. It will take months because the DCA will use the Jacobson formula to allocate a number to each municipality except the cities. And it probably will take at least 6 months. Some estimates will be made. And we'll probably be having meetings with the board and Catherine to go over the need to, well, the requirements of the statute and the benefit of getting a compliance approval from the system, the new system. So good questions, Jen, but the answers are to be determined.
Yeah, I didn't expect an answer. I was just hoping maybe at some point we would get one. The DEP hearing, is there any for May 20th?
We don't have anything to do with it.
Nothing to do with that, okay. And then finally, just a general question. How would I find, I've been looking for the easements that have been referenced in an ongoing application. I have not been able to find any at the county. It is a checklist item. Could somebody tell me where or how I could find it? In general, where it's a checklist item, where would an easement that an applicant insists that they have, where would that be found? I can't find it at the county.
Sometimes on a particular piece of property, just in general, the applicant might have to provide a title search. And in that title search, it would show up if there's any easements of record.
But you would have that, because it is a checklist item for a complete application. If an applicant has come to this body saying that they have a complete application, this body would have that document.
If there are any easements on the property, yes.
Okay,
Sometimes there are documents that don't make it to the clerk's office, not intentionally, but it just, if there was supposed to be right-of-way dedication or an easement, sometimes I've seen it doing surveys where it's just not recorded. It was talked about in an application, but it never made it to the county clerk's office for whatever reason, something that might have slipped through the cracks.
and that's something that this body, if that happened, and the applicant was relying on that element of their application or of the site plan, that's something that this body would have access to or could ask for.
If it's a condition of a resolution of approval, yes.
Okay.
Probably has to be an easement related to that piece of property too, not next door in some cases, right?
If it's being testified that there is an easement related to an application,
Yeah. It's related.
this body would have access to that easement.
Not necessarily, no.
You would just take it on good faith that there is an easement?
No, so because this board would wrap that up as what Dave just mentioned about resolution compliance is necessary. So if it was an approval and they testified that their plans showed an access easement or a sewer easement or whatever, when they go through resolution compliance before they're able to get their building permits, they'd have to show some copy of that. And the reason why, it's probably far and few in between where it slips through the cracks, but a reason why that access easement or that driveway, whatever it is, isn't alive yet, isn't filed, is if the application didn't move forward. But if it was built, constructed, and it doesn't exist, then that's a problem.
One that's been referenced to have existed for decades.
So you can find it usually on the survey. The deed book and page is usually referenced on the survey. It won't just say easement and then show the area of the easement. It'll normally say on the survey, if the survey did their job, access easement recorded, date, deed book page in the county of Sussex.
Okay.
So if there is a survey for the property, that's likely going to be your one place you can find the information about how to search for it. And you can usually search for it online with the deed book and stuff through the Sussex County Land Records.
Thank you, I appreciate your help with that.
Okay, are there any other questions from the public?
Comments?
Okay. So at this time, I think we'll get ready to move into executive session, but before we do, on behalf of the board, I know we've kept people here late tonight, so I'd like to thank everybody who stayed in and asked questions and participated in the meeting with us. And again, as well as those people who may have been watching from home. So thank you very much, and wish you guys all a safe trip home.
Thank you.
Okay, may I get a motion, Mr. Collins?
It would be a motion to approve the resolution that you have before you, which is providing for a motion to go into closed session pursuant to Section 7 and 8 of the Open Public Meetings Act. I do not believe we will be doing anything in open session after you have the closed session, so people may stay, but there's no reason to, there's nothing going to happen other than adjournment, I think. And I hope it's less than a half an hour, but I can't promise anything. So the motion is to go into closed session pursuant to Section 7 and 8 of the Open Public Meetings Act to discuss matters of pending litigation, Diamond Chip Realty versus Sparta Planning Board, and Anand Dash versus Sparta Township Zoning Board, and attorney-client privilege communication. The matters to be revealed to the public upon the completion of all litigation and appeals and the removal of the need for confidentiality. Is there such a motion?
I'll make a motion.
And a roll call,
Do I
please.
roll call, please?
Deputy Mayor Dean Blumetti?
Yes.
Annette Burke? Yes. Christine Dunbar?
Yes.
Vice Chairman Bill Enright?
Yes.
Justin Canellis?
Yes.
Celeste Luciano?
Yes.
Nick Pompilio?
Yes.
Ernie Ragsdad?
Yes.
Chairman Ronde?
Yes.
No action is needed after.
Thank you. Good night.
Good night.
Okay, would anybody like to make a motion to go back into open public session?
I'll make a motion.
Have a second?
Second. I'll second.
Dory, roll call, please.
Deputy Mayor Dean Blumetti,
Yes.
Jeanette Burke,
Yes.
Christine Dunbar,
Yes.
Vice Chairman Bill Enright,
Yes.
Justin Canales.
Yes.
Celeste Luciano.
Yes.
Nick Pompilio.
Yes.
Ernie Reichstad,
Yes.
Chairman Ron Day.
Yes. All right, the motion's passed. We'll back into open session. Again, to the whole team tonight, thank you very much for everything. You guys did a great job. A lot of great contributions all the way up and down the line here, so many thanks. So with that, unless everybody has any other comments, we check before we close out, checking in both directions. Would anybody like to make a motion to adjourn?
I'll make a motion to adjourn.
Do I have a
I'll second.
Roll call.
All in favor?
All in favor?
Aye.
Aye.
Any opposed?
Say, Ernie, you're on.